Happy Friday. It's time for Friday Night Live. We're here with like the thunder rolling. So if we have power stuff, I deeply apologize. I'm just going to let you know at the top of the stream. If power stuff happens, I just apologize in advance for the weather, which, though I'd love to control it, it's just not happening. We have so much to cover tonight for Friday Night Live. We are going to go over just a very few quick bits, stuff that we'll probably dive into more in other content. And then there has been a plethora of unsealed documents. We're going to talk about those. Andrea Burkhart pulled all those together. So many of you contributed to crowdsourcing that another $7,000+ went to charity. Absolutely incredible for the community and incredible of her to do the legwork to get the documents, make them available to everyone. She made them available to everyone. So I'm going to shout out her website and share her YouTube channel and her Twitter handle because she did the legwork. The community crowd funded it, and it is time to be. It is time to just go over those documents and mention it all. So with that, we are going to get going live. I'm going to get my screen set up. Emily, do we have that done in advance? No, because these went live this afternoon and I was parsing them. Also because I recorded today with Nightline to discuss the Girardi case. And so if you are still up after the stream and Nightline is on where you live, I will be on ABC on Nightline this evening. So that's been my day. I mean, aside from getting home at 2:00 this morning from Los Angeles, but other than that, here we are. So if it's your first time catching me live, pop a 1 in the chat. If you are normally replay crew, pop a 1 in the chat too. And if you are not, if you are just replay crew, love you. All the timestamps will be down below. But tonight is really a first look together at these documents. Have I looked at these? Only enough to parse the ones I thought would be interesting for us to cover. So I have not gone through them in depth. I'm going to do other content where I read all of these documents and pull out the most interesting bits. Like we might have to do a hot tea and then a hot legal tea on these to be like, these are the most legally interesting things. And these are the like, OMG, this was in an email type of thing. So we might have to do 2. We might have to do at least 2 things on all of these documents. Yes, it's a lot to cover tonight. Law nerds are like, whatevs, let's ride. Hopefully you got your text. If you're in the text crew at textemily.com, we should roll the intro and just get into it. Don't worry. I know what you guys want to hear about in quick bits. We're going to talk about it. We're going to mention it all tonight. And we're going to have to talk. I think the first thing we're going to talk about in quick bits is, did Amber Heard file for bankruptcy? Because the fake news of it all. So let us just ride. Oh my God. The thunder is rolling for real tonight. Yay. It is so dark and stormy. And I'm living for it. I even made tea because it feels right. It just feels right. That's the kind of night we're going to have. We're going to like get cozy. We're going to have a little tea. We're going to talk a little tea. We're going to look at unsealed documents. Oh, it's going to be so good. You ready? I'm ready. Let's go.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
Oh my God, I love seeing it. I got text, I got Patreon, I got YouTube alerts. It's all working. Rotten Ralph, that's the best news I've heard. It's all working. It's all working. Greatest tube vibes or videos. Sorry, why didn't you bring the rain with you to LA? So inconsiderate of you. Trying. I tried to, but I didn't. So anyway, I'm so excited to be here with y'all too. It's great. I'm ready. Where are you? Oh, Middle Tennessee. You're like, where are you? I'm like, I'm here live. Your Honor, I'm here live. I'm not a cat. But yeah, I see you guys saying we need to update the intros. We haven't had a chance to, it's been so busy. We haven't had a chance, but we are going to do that as we update things. I need to update the podcast intro, the YouTube intro, the graphics for the intro. The team and I have been so busy. We're blessed to be busy. I'm happy to be busy. I'm happy to be busy, but we just haven't gotten to it yet. So you guys were like, cat lawyer. For all of you that I saw on Instagram today, hello. Yes, we had some cat lawyer references today on Instagram. And I saw Ben Chu's stuffed alpaca in the chat. I have one of your brethren. He's not a hostage. He's here willfully. So yay. We're all here together. All right. Let us get into some quick weekly roundup. I'm trying to watch the chat and say hello and do that. But do any of the other law tubers make comments about your intro saying that you're our favorite law tuber? It's not wrong. I just like the ribbing. Oh, wait, here, this. I am everyone's favorite legal commentator, so I don't say LawTube specifically. But no, should I change it to everyone's favorite purple-haired, foul-mouthed legal analyst? I could do that. But it was the tagline at the beginning because it's what the community has always said. They're like, "Oh my God, I love your commentary. You're just my favorite." And that's how I feel about all you. Y'all are my favorite too. So, no, we're over here as a full-on legal commentary channel. And truthfully, when the intro started and when the channel started, I was kind of in a silo by myself. I got to know the others in this community through, not through just creating content in the community, but through other trials. So that's how I got to know everybody. Sorry about the audio. It does happen. I don't know if it's the weather. I don't know if it's the tea is that hot that it sounds like the fire, but the static, it should be gone. Hopefully it has resolved and we're going to keep going. So it just happens. Also, I don't think everybody's got kind of their own thing. So, it is what it is. I'm not wrong. We all have our favorites. And, if you're, who's to say favorite is exclusive? There could be multiple favorites. All right, let us roll into our first quick bit story because I know y'all want to hear this. I might have to update the music on quick bits too. We might need some other quick bits. No, weekly roundup music because it is close to the intro as I'm thinking out loud. But we've got to do a little bit of a weekly roundup. First thing everyone wants to know about, because I keep getting tagged in it, is did Amber Heard file for bankruptcy? Look, I have not seen a single report that has said, according to documents obtained by. No one has said that. According to documents, I have seen no filing at all for the bankruptcy. One of the news reports I went and looked at, because I was trying to figure out where these rumors are coming from, because right now they are rumors. The news reports I have seen are saying things like she declared bankruptcy. Elaine Bredehoff said she had no money. Well, she's not Michael Scott running around going, I declare bankruptcy. You have to file for bankruptcy. And if you file for bankruptcy, there will be a filing. I have seen reports that said she filed on July 20th. It's the 29th. Those things normally upload in like 24 hours. So there's no filing with the bankruptcy courts, which means Amber Heard has not yet filed for bankruptcy. So anyone saying she has filed for bankruptcy is not relying on information from court documents. So the chat is so quick. The chat is like, she did not file bankruptcy. She pledged it. She pledged bankruptcy. Look, I realize everyone wants to know what's going on with Amber Heard's money. I know so many people are counting her change, but If she does file for bankruptcy, we will see it in a court filing. Personally, I'm not rooting for her to file for bankruptcy. This case is going to destroy her career, but she is still a human that has to exist and has a child. I mean, I'm not sitting here being like, take everything. We're going to go through the things that are filed in court. I acknowledge that this rumor is wandering around. I have not seen a filing. When I see a filing, I'll take a look. Here's the thing. If she files for bankruptcy, if she files for bankruptcy, we would need to know what kind of bankruptcy. There are different kinds in the US. So we would need to know what kind of bankruptcy to know how much of a thing this is. Like, are we Tom Girardi style? Are we selling the earrings? Are the Gucci bags getting sold? Is the B going back to the bankruptcy trustee? Or is it a reorganization? Hey, we got some debts. We need to restructure. We need to get in the kitchen, shuffle things around a little bit and say there's room for everybody, even though you didn't RSVP. Yes, it's a Clueless reference. You're my people. We'll have to see what type of bankruptcy she files for. And at the end of the day, if the bankruptcy is not going to help her discharge the overwhelming amount of debt in the form of this judgment. The judgment was willful. It's unlikely that a bankruptcy judge will allow that to be discharged. The bankruptcy code's pretty clear about willful acts not being discharged. That's generally to deal with things like injury torts, so you can't just go discharge it. But, doctors and lawyers can discharge their malpractice debts, but that's another soapbox for another day. So if she files for bankruptcy, it's not going to help with it's unlikely, never say never, it's unlikely to help discharge the judgment, but it could in fact help structure the judgment and structure the way the judgment is paid depending on the type of bankruptcy she files. So, hey, I'm going to pay $500,000 a year for these many years. Hey, we're going to structure the judgment so it goes here and there, but we're not even there yet because the appeal is pending. So, look, I am not rooting for complete financial ruin of anyone. This is going to be a mess for her. Financially, emotionally, all of the things. So if it's filed, we will talk about it. But until then, it's a rumor. I haven't seen any large outlets, the type that you would normally expect to see reporting it. So this is how I look at rumors. Did anyone say that it's based on the documents? When People magazine says based on documents obtained by People, they obtained the court records. Or were given them, one of the two. But they've seen the thing. When I talk about things, I wait and see the thing. And then I tell you I've seen the thing. None of the reports I've seen said based on records. It all seems to be based on speculation. And we'll see what happens. But no, I have not seen that she filed for bankruptcy. Yeah, Cynthia makes a good point. TMZ would have reported on that shit. It's an excellent point. And while there are Amber Heards that have filed for bankruptcy in Pacer, this Amber Heard has not. And I don't want to put people on blast, but there's an Amber Heard whose middle name's Elaine, and I couldn't get over it today. I just couldn't. I'm Amber Elaine Heard. I am so sorry. I am so sorry that is your full name, because after this trial, that can't be fun for you. And I think I would change it. Would you change it? If your name was Amber Elaine Heard, do you just change it now? Like, do you just change it now? Maybe. So to that poor human, don't go looking for that poor human. For that poor human, let's all just, much respect. We are all so sorry. Your parents had no way to know, and that's not your fault. But it's just, what can you do at this point other than be like, I give up? Like, you can't just, how do you even apply for a job at this point? probably has a job, probably is a full ass adult and just doesn't even care. But wow, 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 wow. So with that, I just, no, the Amber Heard we're talking about, this celebrity is Amber Laura Heard. But there is another Amber Heard, as I was searching around for things, named Amber Elaine Heard. Different persons. I just feel bad. I feel bad for Amber Elaine Heard. I do. So our next story, we are going to talk briefly about what happened with Britney in court. And then I'm going to touch on what the prosecutors are asking for in the Shakira case in Spain before we get into unsealings. Before we do that, I'm going to talk, well, before we do that, I'm going to share a word from today's stream sponsor, because thank you so much to NordVPN. I will be right back. A huge thank you to today's sponsor, NordVPN. You know how much I love working with Nord, and in the time we've been working together, they've added some really cool new features in addition to keeping all of your information secure while you are surfing the interwebs. They also don't slow down your internet traffic, which I love, because not only is your data encrypted, but Nord also has the fastest VPN servers. But they've added Nord's threat protection feature. I know, more features. You don't even need to be connected to NordVPN for it to work. Once you enable it in settings, threat protection will make your browsing safer, faster, and smoother without tracking your actions online. Nord doesn't track you either. They are double encrypted and they don't keep logs of your activity. Don't worry about downloading malware, dealing with trackers or intrusive ads, or visiting malicious URLs. Threat protection will neutralize these cyber threats before they can do any real damage to your device or data. Yes, Nord will warn you. So it doesn't matter if you're looking at this for yourself, for your parents, or for your kids. Nord's new threat protection feature can make sure that you feel secure in your actions on the internet. It's super easy to download and install. It works on up to 6 devices, and Nord has an amazing 30-day money-back guarantee. It's risk-free. So give Nord a try today. There's literally no reason not to. I trust Nord to keep my family and I protected, and I hope that you will too. So to check out your exclusive NordVPN deal, go to nordvpn.com/Emily D. Baker. That's nordvpn.com/Emily D. Baker for your exclusive deal, and it's risk-free with their 30-day money-back guarantee. Let's get back to today's show. Y'all, thank you so much. We're going to say hi to a few of our chats coming in from Denver. Thanks, Abra. Thrifting my best life. I had a Zoom deposition and the lawyer asked what, if any, and I lost it. I was laughing so hard I was crying. Elaine, not a whop at all that day. That's hilarious. It's like, what, if any? You're like, stop, just stop. Angie said, I dyed my hair purple this week and I'm loving it. Isn't purple such a fun color? I love it. I was sad when Britney didn't like her hair purple, but I get it. It's a change, but I feel like it was made for me and we're just doing this. Just Jakes, I've been watching for a while, wanted to give kudos for the great coverage and all of your hard work. I appreciate it and thank you. Alyssa said, thanks for keeping me company the past few days. I've been so sick and you have been keeping me sane. Thank you. You're welcome. I mean, there's definitely plenty of content to just pop on and fall asleep to over here. Susan said, have now retired, so hopefully we'll catch more lives. Yay! You'll love being in the chat because the Law Nerd chat is the best chat. Ain't no chat like a Law Nerd chat because a Law Nerd chat don't stop. Or act like dicks. Yay, the Garth quote. I mean, Matt Bond, I understand the songs a little better now that I live in Tennessee. Heather said, thank you for making all this legal craziness for those of us who don't exactly get it. Appreciate everything you do. That's my goal. That's always my goal. I love it. Chat with the Amber Heard pledge bankruptcy. It's literally the funniest thing. It just gave me life. Lisa Williams said, Amber Elaine Heard should keep the name and make bank with it. I think that's a good option too. Just Just be like, that's it. That's what we've got. Let's see. There was one other one I grabbed. Where is it? Super snaps for all my fellow law nerds who took the bar this week. May we all be as successful as EDB. I mean, I like what I do over here. Just act with integrity and it will all work out. It will. Here's my best advice for anyone that wants to become a lawyer. Trust that it will work out. Stay in your integrity. If people try to push you out of your integrity, they are not the right people. And if those people are your clients, tell them the truth. Lawyers who do not tell their clients the truth can probably make more money in the short term, but you will build a reputation and do the most good for your clients by telling them the truth. By the way, I was going to use yeeted in an answer, but thought better of it. That's probably fair. The bar examiners don't always have a good sense of humor. It's totally fair. So for everyone taking the bar, amazing, amazing, amazing. All right. So Britney in court this week, I was there. It was super interesting to see the lawyers argue in their own voice, different than just reading the transcript and different than just seeing them outside of court. Because I will say, for all the standum of Rosengart, when he was out doing kind of the press, and I'm going to cut down, I took some video of both the attorneys and my questions to them. I'm going to put a Quick Bits video together and put that up on the Quick Bits channel with my footage of what the attorneys said and a little bit of my commentary on that. I have not done that yet, but I intend to. If you don't see that in a few days, my perfectionism might have gotten me and I haven't done it yet, but I highly intend to. So it was interesting seeing what happened in court, especially with regard to TriStar. Judge Penny gave a tentative ruling, but it's not final. Rosengart alluded to the fact that it was final-ish, and that was really odd to see. It was just really odd to see that he was like, oh, it's kind of final. He was saying, TriStar's been ordered to do this and TriStar's been ordered to do that. It's not a final order yet, though, my guy. So that's been confusing and a little odd to me, but we will go over all of that when we go over it in depth. So with that, Britney, the big takeaway from court, and if you didn't have a chance to watch my, I've been up for 100 million hours and this is everything that's going on breakdown, then you can absolutely go watch that. That's from Wednesday? In court. Wednesday? That's from Wednesday. But the big takeaway is that James Yeeted Spears was trying to make Britney Spears sit for a deposition, and the court denied it. And that was fantastic. So that ruling really protects Britney. I was so shocked. El Estrada, Emily, please don't you dare pledge your video to us. It's been pledged. It was so shocking to see how hard James Spears's attorney Weingarten was, how hard he was fighting to get Britney's current address. It was creepy to me. Professional legal opinion. Creepy. It was really creepy. She has a fucking fleet of lawyers on her behalf. They know where she is. He should have just withdrawn it, but he was just fighting and fighting and fighting. And it was odd. And so I'm very glad that that was also denied. It was interesting to me to see the court say, I didn't realize there were stalking issues here. Your Honor, what? Where the fuck have you been, Your Honor? This is not the first time Britney Spears has had issues with stalkers, and someone was arrested at her wedding. I imagine that the judge is not keeping up with the news. The judge is not keeping up with what's going on outside of this case, but it was surprising to me. I was like, weird. There is bad weather at my house, and the mods let me know when there is crackling on the mics immediately. I will let you know that YouTube has me on a little bit of a delay. So with that, I will see the notes from the moderators before I see y'all's notes. So just know, yes, I am having bad weather here. It is causing a little bit of crackling. my mods will always let me know, and then it will be fixed. And then, so by the time you type it, I've generally addressed it before I see the messages on delay, because that's how YouTube does the thing. So just so y'all know, we are doing our best, and I appreciate you. I'm glad you all like the hair. I do too. I needed it not in my face. So yes, the audio is delayed, which is hard. The mods have us. All right, let us get into what's going on with Shakira. Her hips don't lie, but Spain is saying she might not have paid her taxes. And this is a really interesting story, because I remember when it originally broke, and then I don't know what we were doing, other things maybe, and I didn't cover it then. But this is, again, when I go through news stories, I look at least 3 or 4 different sources to see which material they're sourcing, so I can go through the different things. Pop star Shakira could face 8 years in prison in a Spanish tax fraud trial. Ooh, sorry. I love this Guns N' Roses shirt, though. I love this Guns N' Roses shirt, though. All right. Prosecutors in Spain said Friday they would ask a court to sentence Colombian pop star Shakira to 8 years and 2 months in prison if she is convicted in her expected trial for alleged tax fraud. Here's the takeaways. If she is convicted after trial, if it goes to trial, they will ask for 8 years. That doesn't mean the court has to do that, but that's what they're asking for. That doesn't mean she's going to prison for 8 years. I've seen the internet's been very confused. It doesn't mean she's going to prison for 8 years. If it goes to trial, if she is convicted, that is what they will ask for. So let us continue on to how we got here and why this case is going on. Shakira, whose full name is Shakira Isabel Mabarek, I think, Ripoll, is charged with failing to pay the Spanish government 14.5 million euros, $15 million in taxes between 2012 and 2014. The prosecutors say they would also seek a fine of 24 million euros. So that's the back taxes plus penalties. The indictment details 6 charges against Shakira. The singer this week rejected a settlement deal offered by prosecutors, opting to go to trial instead. A trial date has yet to be set. I have never practiced in Spain. I have never been to Spain. I'm sure there's rain on the plane in Spain. I have not been to Spain. This is not my jurisdiction. But what the information is telling me is the trial date has not been set yet. This is very, very far down the road. This could be years down the road. Minnie Red's November Rain is a fucking iconic wedding song. Frankly, her name is Shakira. You're absolutely right. So with that, a trial date has not been set. This is going to take time. Her publicist in London said in a statement Friday that Shakira has always cooperated and abided by the law, demonstrating impeccable conduct as an individual and taxpayer. The publicist accused the Spanish tax agency of violating her rights. Shakira's Spanish public relations team said earlier this week that the artist has deposited the amount she is said to owe, including 3 million euros in interest. So she's put the money in trust. Hey, I'll wall the money off and put it in trust, which is a pretty baller good faith move. But this sounds like the artist has deposited the amount she is said to owe, including 3 million euros in interest. So she's put 14, 15, 16, 17.5 million euros in trust. That's a pretty good faith move, I would think. Shakira recently ended an 11-year-long relationship with FC Barcelona star Gerard Piqué, with whom she has 2 children. If I pronounce that terribly, I apologize. The family used to live in Barcelona. What I've gleaned from other reports is that she said that during these tax years, she did not live in Spain. I don't know what the tax laws are. International taxation is such a complex issue. She's a Colombian national. Did she live in Spain? When did she live in Spain? Did she earn funds in Spain? It's a deeply complex issue. She is saying in other statements and other reporting that she did not live there during that time. She denied a plea deal. They said they want to ask for 8 years. Is there still time for this to plea? Yes. Has the date been set for trial? No. Thank you. The rain in Spain stays mainly in the plane. Appreciate it. So that's where we're at with Shakira. We'll see. I mean, if they're saying you owe taxes and you're saying, but I didn't even live there, I think that you probably need to sort that out. And if she's like, I put it in trust, I hired my lawyer, come at me, that's her right. So we will see what happens with Shakira down the road. So they said in court, this is what we'll ask for. Okay. If they're asking for prison and a plea deal, I imagine Shakira's like, I'll give you money. I'm not going to prison though. Like, what we're not going to do. So, chat, I've seen a number of comments now about Amber Heard and her child. I'm just going to remind you that we do not touch on people and their kids. We leave the kids out of it. And if that is not verified by 1,700 people plus, it is a rumor and I am not touching it. Because again, I don't wish that on anyone or any child. So I see it, but the mods will start yeeting it that we do not mention the kids. It's like housewives up in here. We don't talk about the children unless the children are actually part of the legal filings that we need to discuss. And I appreciate you. So thank you for abiding by the rules. Absolutely. The kids are off limits. If kids are in a filing, we will talk about it, but the kids are off limits. So thank you all for being respectful. The chat believes in not being a dick and in basic human decency, even for people we don't like. I know that can feel challenging because on the internet, normally we don't extend grace to people we don't like, but the law nerds do. The law nerds extend grace. Why? Because we're law nerds. We're going to talk about your legal tea. We're not going to drag your life into it. So let us not drag people. Thank you, Coffee Girl. I agree with you. The remarks about AH, they are going too far. Don't need to go there. Yes, we do. Thank you, chat. Appreciate it. I saw a couple of comments and wanted to make sure that I addressed it directly. And this is Apple Jam PB. You don't have to like someone to treat them like a human being. Yes. Chat, you're the best and I love you. That's just how we do it here because we're law nerds. And look, if we do that, then we are as bad as those that are rolling around for either side in any of these controversies, trying to burn it all to the ground. We are able to have nuanced conversations. We are able to understand that two things can be true at once, and we are able to extend grace and be decent, kind humans while still talking about people's legal shit. Two things can be true at once, because what we're not going to do is drag people. It kind of goes along with the name calling. It's along that. Oh, we don't talk about Bruno, no. The amount of people that just said that are amazing. You guys, you're the best. I love you. Look, it's just what we do here. We're law nerds. All right. My tea is making me internally hot. I'm pretty sure it's just raised my metabolism. I'm like, woo. How about Brad and Angelina Jolie? I don't talk about their kids either. We're going to get back to everything going on with the wine early next week. So before we get into the legal filings, there are two matters of housekeeping I need to let you know about. First matter of housekeeping. A lot of you who follow me on social media have seen the incredible boxes that we sent out to some of our friends of the channel. Those are going to be available for purchase for the Law Nerds too. They are exclusive merch items. They are very limited quantity based on resources and things. But Those will be made available to the members at the exclusive merch tier first, and then down from that. That tier is closed on YouTube. Some of you are still in it. Don't worry, I got you. But that tier is open. It's the 3L tier over on Patreon. What I will say, because today is the 29th, I have not set a release date with my team. And when I do, I'm going to share that on Tuesday. And I'm going to share what the box looks like in hands on Tuesday. I've been sharing it on social, and I'm sure you've seen it. But if you want to join over on Patreon at that tier, Patreon, until we have finished switching things with them, Patreon bills on the 1st of the month. Today is the 29th. So just know that you can wait till tomorrow or wait till August 1st and then join, and you will not miss anything. So I am waiting until after the 1st of the month so that those of you don't feel pressured. I fucking hate that. It's like, oh, I have to do this to do that. Give it a day or two and we will do that. So I will update you about that on Tuesday when we have the launch date. I just need to hammer down the final details with my team because I've been traveling and my brain can't do two things at once. So July has 31 days. Yes, till the 1st. Till the 1st, not tomorrow, but till the 1st. So what is Patreon? Patreon is our members community at lawnerdsunite.com that has the members only podcast, the members only, options for members only Zoom calls at different tiers, options for other exclusive benefits over there. So is there any chance for a possible giveaway for a few merch items? Samantha, it's like you're reading my brain. Okay, so look, I am not a marketing person at heart. I am a lawyer. The marketing people are going to be like, just wait. Don't tell them you're doing a giveaway too. I'm doing a giveaway too. So if I upgrade my Patreon membership now, will it charge you today and again on the 1st? Courtney, I think it will. I would wait till the 1st. Just please wait till the 1st. I think it will. Set an alarm in your phone. I don't have a lot of money, but I think you're great. Atlas, it's fine. These are extra benefits, which I truly do wish I had the bandwidth to offer to everybody. And if I could, I would. But we will absolutely do a giveaway, and we will absolutely make some of those available to the exclusive members. So we will have options and that. All right. So that the exclusive merch goes to the exclusive merch tier first. Georgia Mitchell asked, are there 1,700 people here or 17,000? There's 21,000 across platforms now. So over 21,000 on the YouTubes. We do it like that over here. We do it like that on our streams. So let us get into, oh no, I had one more thing I needed to talk about, y'all. In August, we have to switch the streaming schedule. And it breaks my heart to do it, but I have to. My kiddo has kiddo family stuff on Fridays as we get into the school year, which starts very early here in Middle Tennessee. And with that, I cannot do consistently the Friday night lives. So what I've talked about with my team and with the mod squad is that I am going to be streaming a Coffee and Cursey Words on Tuesday and Thursday. And the Coffee and Cursey Words on Tuesday and Thursday will both be at 11 a.m. Central Standard Time. Or Central Daylight Time. I just realized the difference between CST and CDT, like it switches, like CST is when we're on Standard Time and CDT is when we're on Daylight Time. I didn't realize that they switched. The things they never tell you. I'm like, I'm an adult. How did I know this? So what is happening? But we are going to have to do Tuesday and Thursday. I will do some limited Fridays when I have availability, and I will let you guys know. But for the fall, like through the new year, we're going to have to do Tuesday and Thursdays. So I love our Friday night lives. I'm going to ride on them sometimes when I have time, but I need to be there for my kiddos' stuff first. And as my life changes and as my kids get older, we will have some flexibility for sure. So we will have some up and downs. There will be stuff, but I will miss you on Fridays. So here's the plan. if all goes to task. Tuesday at 11 a.m., Coffee and Cursey Words. Wednesday at 11 a.m., a premiere of the coffee and a premiere of the video for the, let me fix this up. Today is just spicy. A premiere of the video for the podcast with me in the chat. Thursdays at 11, Coffee and Cursey Words, or maybe we call Thursday something else. And that will be good. So that will be our days. We will be 3 days a week together at 11 in different ways. And then we will branch out when we can. And that's the plan. So thanks everybody for understanding. And we're going to just, all the band parents in the chat are like, yep. Some of you might see me serving nachos at a high school football game. So that's what that is. And you know what? I've got to be honest. I love our Fridays. I really, really do. I love our Fridays and I will miss them. And I will absolutely be like, oh, we don't have anything this week. We're going to slide on in there and maybe do a Q&A stream, a drink stream, invite the other law tubers on, talk about cases we love, do all the things. But the fact that I have flexibility to say, hey, this is the night I'm going to be with my family just is so incredibly special to me to know that I can just block that out. And I'm so, so deeply thankful to all of you for your support of what I do here to allow me to also be the parent that I want to be too. And so it means the world to me, and you guys mean the world to me. So our time and our energy is limited in this life, and I want to make sure I can spend it with you and with my family and make sure that balance works. And I am so thankful that we can, right? What a special thing. I feel so blessed, and I just am so, so, so thankful. So yeah, I know somebody is chopping onions. We need to talk about unsealed documents. Family over work, love you're here with us, but family first. And the thing is, I get to make that choice now. And for years, that was not in my control. And it's not lost on me that it's in my control now. And that's what makes me so emotional. I know not all of you have that choice. And you have to fight for it. But the fact that I've been able to take control of my time back, it just blows me away, because for so many years I thought I had no other option and no other value really if I didn't do the job that I was doing. And so being able to make those choices helps me feel like I'm living not just my best life, but a life that's completely aligned with what I value most. Because it's easy to say, oh, I value family. But if you don't have time to spend with family, it makes it very hard. So, so thank you. I saw a chat. Daniel's like, stand-up comedian getting ready to do a show. And I'm like, let me get that Emily D. Baker tea before I go up. LOL, love the commentary. Look, Daniel, don't let me get you down. Let's talk about some fuckery. It's the reset that we need. So thank you all for the love, for the support, and for letting me just share how special it is that I get to that we can gain control of our life. We can set the boundaries we need, and we can set the time that we need aside for us. And that is huge. And the thing that's hard for me is I really like doing this with all of you. Lexi, has he been in band camp this summer? Yes, he has. It's been hot. He's grown so much as a person. He's just grown so much as a person. And I am so thrilled to see it. And I am so proud of him. Completely his choice. And I am a very, very proud parent. So I can't believe my kid's going to high school, y'all. I I cannot believe it. I just cannot believe it. All right. Ooh, let's talk about some tea while we sip some tea. These documents are unsealed, y'all. We need to give a huge shout out to Andrea Burkhart. Hold on. I had her Twitter pulled up and then I lost it because she did the legwork on this and made it publicly available. That is such a fucking boss move. And I am so deeply grateful. She went above and beyond to make this happen. And so a huge shout out to Andrea, not only for organizing the community to raise the funds to do this. And she's at A. Burkhart Law. Not only did she raise the funds to do this and then donate over $7,000 to charity, but she made the documents available for everyone. So we're going to go through her Twitter after I go through the things I've put aside. But she put a quick little video up, put these up on her website. You can follow her on Twitter. You can follow her here on YouTube. Everything's under A. Burkhart Law. She made this possible, and I am so grateful. So if you want these documents for yourself, they are up on her website. So make sure you go get them there. That's where I've gotten them too. To everyone in the community that crowdsourced this, thank you. She could have crowdsourced it and kept them to herself and didn't. And it was like, I'm making this available for everyone. I'm making this available to the community. Let's all work together. That is just, boss level. Can I say it's S tier? S tier is good, right? Griffin keeps talking to me about S tier bosses, and I'm like, is S tier great? Like S tier is great, like the bossiest bossed ones? Yeah, I think so. We're gonna try to use the language these kids use without quite knowing what we mean. So absolutely love seeing you guys share the love that Andrea did this. Love that you guys can go support her over on Twitter. Let me just make sure I link her. I'm going to link her Twitter so that the mods can just share it and share it in the chat. S tier is good tier. Right. Super great. S tier is top. I did it right. So you guys make sure you follow Andrea Burkhart on Twitter too. And I love that she calls herself a legal color commentator. It's so great. It's so great. I'm going to tell you what I want to cover tonight so you guys know what's coming up. These are the things that I want to know. Let's see. Pretty accountant, did someone really crowdsource over $30,000 for legal documents of people none of us know personally? I don't think it was quite $30,000, but yes, to get the sealed documents, we're all deeply invested now. So I'm going to look at the suspension bond. We're going to talk about the suspension bond, bonding, appeals bonds. We're going to look at the motions regarding Amber Heard's prior acts of violence, the motion about sealing the jurors' identities, and then some of the medical examination motions, a transcript from the UK case, and then there's a motion for sanctions and some stuff regarding a protective order. And we're going to go through it. Yeah. Mama C asked the question that we needed to get to first, and I think this gets us started first. Why do documents become unsealed or sealed during proceedings? I know we talked a little bit about it, but I forgot. Thanks for everything, Mama C. That's a great place to start. These documents were sealed during the course of the trial. They were sealed for privacy. They were sealed not to taint the jury. They were sealed because of the high-profile nature of this case, and some because of the sensitive information. Obviously, if the jury pool hears that there's a motion regarding prior acts of violence, if anybody comes in and is like, oh, I saw this news article about prior acts of violence, it's going to be a problem. So there were a lot of considerations. Some things remained sealed, and I went through that when the court made the order about what was getting unsealed and what wasn't. So at the hearing on June 24th, when Judge A made it very clear that she was going to unseal the things that were sealed to protect it from the media, protect it from a potential jury pool, that kind of thing, it seemed like Elaine was like, whoa, 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 whoa. What do you mean they're getting unsealed? And the judge is like, I always intended for these to be sealed because of the nature of the case. The case is over. And so if the case is over, they don't need to remain sealed. So the court unsealed them, but wasn't just putting them up on the court website. The court is no longer updating the publicly accessible site, which means they had to be purchased from the court. And that is what Andrea Burkhart crowdfunded and got done for everybody. So that's how we access these. If you want any of them, they are over there. I'm going to go onto Twitter at the end of this and take a look at her takeaways, but let's look at some of these documents for the first time together. I did go through the ones I thought would be interesting and would have some of the transcripts attached. I think that's closer. The documents were about $3,300. I think that's closer to correct. That 3,000 number sounds closer to correct based on the price per page. Trust, the amount I spend on documents a year, I get it. Depending on the jurisdiction, like Nevada is just like, hey there, hey, that's gonna be 50 cents a page. And when people file long motions in Nevada, I'm like, Washington State too. Some of them they're like, let me spend your money for you. We got you. And some states are charge much less. And you're looking at like 10 cents a page or whatever. So it just depends on the jurisdiction. Oh my God, Keone's like, some documents cost $250 a page here in Hawaii. You don't ever ask. Don't ever ask me to cover anything. No, I will. I would do it anyway, but it's a lot. $250 a page is insane, but I get it. And transcripts cost more because you're paying the court reporter. I get it. All right, let us pull it up. So for those of you talking about the Toddy without a crystal ball case, that case was in federal court. Thankfully, Pacer is so easy. It's so easy to work with. The federal system makes it real easy. All right, let's pull up this first order and get into it. This is an order. This is from, it looks like the 15th day of July to me. It appearing to the court that a judgment was rendered against both parties in this matter, it is therefore ordered that the clerk of court shall receive and hold any suspending bond submitted by either party in the amount of the judgment rendered against that party plus 6% interest per annum in accordance with Virginia Code Section 801-676.1. So if anyone puts in a suspending bond, meaning that the other party can't go after you to collect the amount, this is setting the amount of that suspension bond. And we've talked about the suspension bond a lot. In my content, I've tried to be very mindful of how I talk about the suspension bond, because the court has said there will be a suspension bond, but in the transcripts, but the code says it is discretionary. We know that there's a $500 appeal bond. So for me, it's always been gray, and this is not the jurisdiction where I practice. So I've always said, this is what I think. And what I think, especially if I don't tell you this is what it is, I will tell you this is what it is, no exceptions. Josh Duggar's maximum sentence. This is what it is. But when I've talked about this, I have tried to be mindful, and if I haven't, I apologize. But I have tried to be mindful of saying, this is what I think, and this is what it's based on. They can choose if they file this, or they can choose to go after each other, but both of them paid the $500 appeal bond. So that's what it is. We will see. If a suspension bond is submitted, we'll hear about it, and then we'll hear about it. So with that, I have tried to be clear that I don't think I have ever said, it's hard to say never, I don't think I've ever said Amber Heard has to pay this or she can't appeal, because with the code, there was a contradiction between the code and the court for me. And that is, that's always a little challenging. I'm like, well, the judge is in that jurisdiction. I'm just reading the code. So that's what that is. But the court ordered it. This is a court order. This order allows the court clerk to receive it if it's paid. So Kim said Johnny Depp paid his $2 million. I haven't seen the documents yet, but when I see them, I will absolutely look. And I wouldn't be surprised. I mean, we've heard reports that Johnny Depp earned over $3 million selling his art. I'm not surprised by that. I'm not surprised that he posted a suspension bond. If I'm Johnny Depp, this is my strategy. This is where I'm at. If I'm Johnny Depp and his lawyers, I'm not giving her $2 million until this shit's all done. I'm not doing it. I'm not doing it. So if I'm Depp, I'm like, here, hold the money, just hold it. It's not that deep to me. But his is only 2 million plus the 6% for a year. Hers is 10.3 million plus the 6%. Could she get a bond company to pay for it so she's not putting up the entire amount of money? Theoretically possible. Could she just force Johnny Depp to spend his money to try to go after money that's not sitting in her bank account? She could. That's all going to be a strategy decision on her part. Like, come get it. Good luck. There's nothing there. Good luck. And Johnny Depp's like, I'm not letting you get to this $2 million. It makes way more sense for her to not file it and way more sense for him to file it for me. That's what makes sense. So I'm going to go over this code section, which I've reviewed. I don't remember if we've gone over it. We've gone over so many. I think we went over most of the ones with regard to the jury instructions. So let us just go over it again. I mean, it's still pulled up in my it's still pulled up in my Googles. So let's just go over it again as we're pulling it up. Let's see, where are we? 676.1. Because I wanted to know. So we're almost having like a research with me stream. Isn't this fun? So this is what I went through. Then the judge said different stuff. And then I said, this is what people are saying. We'll see what happens. Security for appeal. Security for costs of appeal of right to the Court of Appeals in civil cases. A party filing notice of appeal in civil cases shall simultaneously file an appeal bond or an irrevocable letter of credit in the penalty of $500. That's the one we've talked about. That's the one they paid. They had to pay the $500 appeal bond, or such sum as the trial court may require subject to subsection E. So this is where it's like, but is the court requiring it? The court's allowed to require a suspension bond. And the court said will. But we haven't seen it. So that's subject to subsection E, which is down here, increase or decrease in penalty or other modification of security. Conditioned upon paying all costs and fees incurred in the Court of Appeals and the Supreme Court if it takes cognizance of the claim. If the appellant wishes suspension of execution in a civil appeal, the security shall be conditioned and shall be in the sum as the trial court may require. And the trial court told us what they require. But this did say, if the appellant wishes. Choose. Choose if you choose. Security for costs or suspension in criminal cases. An appeal bond or letter of credit is not required in criminal appeals for security of costs. A suspension bond is not required for criminal appeals. Great. Which makes sense. Oftentimes when people are criminally appealing, they don't have the money to do that. Security for suspension of execution. An appellant who wishes execution of judgment, meaning you pay me now. Pay me now. We're going to take your shit. Pay me. Pay me. An appellant who wishes execution of judgment or award from which an appeal is sought to be suspended during trial or during appeal shall, subject to the provisions of subsection J, file a suspending bond or letter of credit conditioned upon performance and satisfaction of the judgment. And the judge has already issued that amount. It goes on to say execution shall be suspended upon filing of such security, meaning it can't be enforced. You can't go get the money. And the timely prosecution of such appeal. Such security shall be continuing and additional security shall not be necessary except as to any additional amount that may be added. So if it goes on for years, it seems like you don't necessarily need the suspension bond. So with that, that's what the law says. The court, well, if you guys listen to this week's podcast, the court shared, or the court's bit about that was will be. I don't know if what Elaine was doing was trying to get the court to reduce the amount of the bond or not. So, yes, we have electrical storms in the area. The static should be gone. The mods let me know. So thank you. All right. Let us get to the next one. So hopefully that absolutely clears up the issue. If I'm Johnny Depp, I'm absolutely putting the money into a suspension bond. If I'm Amber Heard, I don't know if I'm not worried about it. Still annoying. It's annoying that it's still crackling. Sorry, y'all. I hope that's better. All right. Let us get back into what's next. I'm still blaming StreamYard. All right. StreamYard's like, don't blame us. Because. All right. Because. Let us get into our next document. This is John Depp. Let's see. There we go. Filed under seal, Plaintiff Depp's memoranda in support of motion to question defendant Amber Heard on prior acts of violence. I pulled this up because a lot of us have heard of the past allegations with regard to Amber Heard's ex. This did come up during the trial. We heard about it during the trial, but I wanted to see what questions they wanted to talk about. And that was super important to me. So while I was fixing my mic, I missed a super chat that was incredibly generous. I don't know how I didn't even see it, probably because I was reading things that were coming through, but let me go and find it so I can say thank you in close time. Bobby Cat, thank you. It's just, we do things with integrity because we do. And then sometimes we make faces. Let us get back to this memorandum of support. Thank you for that kind and generous super chat. I appreciate it. The reason I'm bringing this up is because I want to see what questions they wanted to ask. What did they want to get into? Because we saw what they did get into. So, Mr. Depp should be permitted to engage in the following limited inquiry as to Ms. Heard's prior acts of violence, including the assault / battery of her ex-girlfriend, Tasha Van Ree. Let's see. Oh, that's so much better. Did we just learn something? Yes, that looks so much slay. Okay, we're so happy with the way this document looks right now. Work. You guys, I'm telling you what. Oh, nope, don't like that nearly as much. The dual monitors have just made everything better. They've just made absolutely everything in my life better. Plaintiff John C. Permitted to ask the following questions. So these are exactly the questions they wanted to ask. And we can juxtapose it to what they did ask, because there's only some. Isn't it true, Ms. Heard, that you've been violent with other people besides Mr. Depp? It was basically along those lines. You have previously been arrested for domestic violence, correct? That didn't get asked. You assaulted your ex-girlfriend, Tasha Van Ree, in Seattle in September 2009, correct? That didn't get asked. Ms. Heard, if you would please take a look at the articles in front of you. The first one is a June 7th, 2016 article from USA Today entitled Amber Heard Arrested in 2009 on Charge of Hitting Girlfriend. Do you see that? We know they wrote out their questions. And the second article is also from June 7th, 2016 from TMZ titled Amber Heard Arrested for Domestic Violence Against Girlfriend. Do you see that? They got to show her the articles, but they didn't get to ask about it in this way. Simply put, the testimony at trial has opened the door to such questions which are consistent with the court's prior rulings. This is from May 16th, 2022. So this is before, this looks like it was filed before the trial. But they are saying that the testimony at trial has opened the door. First, both parties in this case have been accused of being violent with each other, and the parties have at multiple times claimed self-defense in response. Exhibit 1, trial transcript day 7. Oh, no, the trial would have been going on. Wouldn't this have been June then? I'm confused on the date on the filing. Hold on, let me see the date this was signed. And we've got I pulled things with transcripts. I wanted to see those more than anything. What day is this signed? Oh, May 16th, 2022. All right, there we go. So whatever happened early on, well, Emily, keep reading. We're going to get to the transcripts. Just go to the transcripts, woman. How long did oh, that's right. It did start in April. Oh, that's right. It was, why am I thinking June? Look, time is a construct and my brain is lost. This did go on the entire month of May, and you're right. Closing was May 27th. So this was right smack during trial. All right. I would need to go back and look at the calendar to see if this was during the court break. So they say Exhibit 1, trial transcript day 7, Mr. Depp describing self-defense. Exhibit 2, trial transcript day 15, Ms. Heard claiming she threw a vase at Mr. Depp in self-defense. Such claims open the door to evidence of prior acts of violence. And then they talk about the rulings about that. And indeed, that is consistent with the court's rulings in this case. As the court knows, there is only one prior instance where Mr. Depp was accused of violence against another person, the Brooks v. Depp litigation, where Mr. Depp has been accused of punching a crew member on the set of the film City of Lies. Mr. Depp filed a motion in limine to exclude such evidence, but the court found that Brooks can be used for liability just in rebuttal of any self-defense claim. Ms. Heard was then permitted at trial to ask Mr. Depp questions on cross about the Brooks case and the alleged assault, trial transcript day 8. Question, and you're currently in a lawsuit for assaulting a crew member on the set of one of your movies in July 2018, correct? Mr. Depp should be permitted to ask about Ms. Heard's prior acts of violence as well. Fair. Second, Ms. Heard's prior violence and arrest speaks to her reputation, which is clearly at issue in this case. Accurate. The arrest took place in 2009, just 2 to 3 years before Ms. Heard's relationship with Depp began, which means questions on Ms. Heard's arrest would be consistent with the court's ruling on Mr. Depp's prior arrest shown in the following excerpt from the court's order in Depp's motion in limine. I wonder if that's why this was sealed, because those motions in limine were all sealed until now, and it's like a flood. This is their order from then. Ordered that Mr. Depp's motion in limine number 5, motion in limine, to exclude testimony regarding Mr. Depp's prior arrest and incidents of violence is granted as to liability issues and evidence and testimony regarding the arrest, but is denied as to the reputation issues for damages. But such evidence shall be limited to 5 years before the inception of Heard and Depp's relationship through present. The court may give the jury an appropriate limiting instruction. They say, moreover, multiple major publications wrote articles about the arrest, and then it cites the ones we just cited above. And then they cite additional transcripts which are attached. Third, Miss Heard has opened the door with her own testimony. We yelled about that. Do you remember this? We yelled about that. I yelled about that. We all yelled about that together. Miss Heard opened the door with her own testimony stating, I know you don't come back from that. I mean, you can't hit a woman. You can't hit a man. You can't hit anyone. I thought so too. See Exhibit 2, but she has hit a woman before, multiple in fact, they say. Mr. Depp should be able to question her about it in rebuttal. Fair. Conclusion. For those reasons, Depp should be permitted to ask. This is the right way to do it, by the way. Ask the court. Ask the court, Your Honor, can we talk about this? This is what we're talking about. I absolutely thought that she had opened the door to it. And the court limited some of this questioning, and we saw that the court limited some of this questioning. So, Exhibit 1, transcript of jury trial day 7. God, I love a transcript, because some of these are going to have, hopefully, sidebars. Do we have sidebars? I want sidebars. Give me sidebars. Let's see. And I would have to show you the sort of how I try to avoid the attack. Please do. If it's all right, Your Honor, the court, yes, sir. This must be Depp. I'm looking this way to the door of my office, and the bedroom door is where you are. So this is Depp talking about that incident what they just talked about up above. I don't remember exactly which line they cited as to the trial transcript on day 7. This is about the broken nose. So I'm just getting clobbered from behind, and one's natural primal instinct is to kind of duck and cover. So I ducked and covered, but they didn't stop. So I came up like this, indicating sort of protecting my face. But at the same time, with her arms swinging wildly, I put my arms out and I was able to get her into a what do you do? A bear hug or something, just to stop her from hitting me. And so that's the first transcript that they cited from that testimony. So let's see. This is trial day 15. Ms. Vasquez, objection hearsay. The court all sustain as to what she might have texted. All right, next question. Without saying what you said in the text, explain why you were sending it to your mom. Amber, I was reaching out. I was very lonely in what I was living in, and I wanted help. I wanted advice, help. I just wanted to talk to somebody and figure out how I could make this stop. And this picture you took of yourself in March 2013, I did, Miss Bredehoft. And then this goes into those exhibits and the text exchanges from there. Amber was like, I had thrown, well, Johnny slapped me. I had thrown well, Johnny slapped me. I walked away from him, and that made it worse. We got into like a shouting match, and he did this thing with his body where I could tell he was going to hit me again. I picked up I remember it was kind of like a little, not a pot, but like a vase. And I remember I got away from him enough as he reeled back. I threw it in his direction and actually managed to get away before he got me. He grabbed me by the arm and he kind of just held me on the floor screaming at me. I don't know how many times he hit me in the face, but I remember being on the floor in my apartment and I remember thinking, how could this be happening to me again? So that's that. Let's see. I'm looking for sidebars. Trial day 15. Is this the same day? So that's the throwing the vase incident. This is Amber Heard testimony. The questions are not in bold. She is in this case, it's Amber in bold, but this is question and answer. And then we're getting to exhibit 3, transcript of hearing day 1. This is what I wanted to see. The court, thank you. I'm going to grant in part and deny in part. I'm going to grant as to liability issues except for the Brooks matter. And Brooks can be used for liability just in rebuttal of any self-defense claim. I'm getting a little specific, but that's for liability. I'm going to deny as to reputation issues for damages. So liability, I guess I should back up a little. Liability, go back, the sidebar's on the side. Okay. Chat, you're the best. You're like, you missed it. I don't think this is a sidebar. This is all Amber testimony. Oh, here it is. Let's see. Objection hearsay. Oh, this one. Miss Bredehoff, can you bring up 170? Thank you. I scrolled too fast. Thank you, Michelle. And if we can, Amber, just for the start, Miss Bredehoff, if we could scroll. Okay, let's scroll. Your Honor, I'm going to object hearsay. Let's wait until we get to the spot. Elaine. She knows what's coming. Let her object. Question. All right. And is this the picture that you sent your mom on 3/23/2013? Yes, it is. Ms. Bredehoff, Your Honor, I'm going to move for admission of 170. That in particular, that picture that's on the text. The court with no words. Ms. Bredehoff, well, it says from 2 weeks ago. Ms. Vasquez, Your Honor. Ms. Bredehoff, if we redact from 2 weeks ago, can we admit it and then just have the showing that she sent it to her mom? Ms. Vasquez, may we approach, Your Honor? She can't just say all that in front of the fucking jury. Ms. Vasquez, this is highly prejudicial. She just read it into evidence. She just read into evidence hearsay. She did. The court, I sustained the objection. Ms. Vasquez, I know. Sustained means don't do it. That's what sustained means. Don't say it. I sustained the objection. Ms. Vasquez, I know. The jury's been instructed about if I sustain it, they'll be instructed again on it. Ms. Vasquez, thank you, Your Honor. Ms. Bredehoff. So I just want to have the top show that she sent it to her mom and what date, and then we can redact the from 2 weeks ago. That's not how that works, and this doesn't flow page to page, unfortunately. Because this is 4240 and this is 4277, because these are different parts. Oh, because these are all in crazy order. So yeah, we don't get the rest of that sidebar. But she's, Your Honor, this is highly prejudicial. She's right. Cinnamon reads, she did a lot of underhanded things, and still lost. Yes. And the thing is, I think it was part of the incompetent shtick. It was like, but I just want to, Your Honor, I just want to have it say it was sent 2 weeks ago on this date, and then the jury's heard it. All right, let's get back to this transcript. This is from transcript of hearing day 1, March 30, 2022. Let's see. Motion in limine number 9, and we'll get to those in other content because we just haven't gotten to those yet. Mr. Crawford, Your Honor, Ms. Heard took issue with the specificity of this request. She cites one example in support of her argument that the request is vague and indicates that she is confused as to whether possible gifts from Ms. Heard from Mr. Depp would fall within the scope of this motion. And I'll confirm that it does not fall within the scope. So I hope that clears things up. Turn to the rest of the motion. Simply put, whether Mr. Depp lived an ultra extravagant lifestyle has minimal probative value at best. So just the ruling. And then they moved on to another issue. Trial day 8. This is, let's see. This is about Depp and Rottenborn on Cross talking about the Brooks matter. Exhibit 5 from USA Today. Amber Heard arrested in 2009 on charge of hitting girlfriend. So this is from June 7th, 2016. And then they go into the arrest. And then Exhibit 6 is Amber Heard arrested for domestic violence against girlfriend. Exclusive from who? Is this from TMZ? Yep. The photos are so weird when they're photocopied terribly. Just photocopied. It's so weird. All right, jury trial day 9. Let's see. There are plenty of negative stories about you prior to that date, weren't there? So I've been in this racket of Hollywood since 1984. Mr. Depp, I'm asking you a yes or no question. There was plenty of negative news stories about you prior to May 27th, 2016. From 1984 up until then, there are both. So of course people write negative stories. And then they're going into that. And then it looks like we have a sidebar. Can you be specific about the stories? Of course, there have been negative stories. Mr. Rottenborn, permission to approach, Your Honor. All right, Your Honor. I have here numerous exhibits in one sort of compendium. All press articles about Mr. Depp, if I may approach. All right. The Rottenborn did it the right way. I have a compendium of articles about Mr. Depp. Great. May I approach? Great. Thank you, Rottenborn. He was by far the best lawyer on this team. They should have used him more. Your Honor, let's see, Ms. Myers, Your Honor, having received this, I would like to preemptively lodge a hearsay lack of foundation. The court, he hasn't got them into evidence. Are you moving these into evidence? Mr. Rottenborn, no. I'm happy to approach, but they are certainly not being admitted for the truth of the matter asserted, but I'm happy to approach. All right, come forward. Great. Sidebar. That needs to be in bold. The court, I mean, if they don't come in, you're just going to use them to what? Judge A, you're going to use them to what? Fan yourself. I wish I had paper. You're just going to use them to fan yourself. They are emotional. Your Honor, it's an emotional support compendium of articles. This is going much more difficultly than I had anticipated. I mean, if they don't come in, you're just going to use them to what? Judge A definitely was a little sassier on Sidebar, and I love it. Rottenborn. So yeah. The response is, so yeah. The court, he said that there were articles written, so it's not impeachment. What is it for? You said he said there were article written, so it's not impeachment. Fair. Impeachment means they're catching him out on something and bringing the receipts. Mr. Rottenborn. I wish he said so yeah again. Mr. Rottenborn. So I'm going to introduce them as evidence. So defamation, we focus a lot on falsity, but the words also have to be defamatory. Your Honor, I would like to remind this court that there is absolutely no evidence of mens rea, and the law tells us that without, I'm going to flub the line from Legally Blonde, but without a vicious will, there can be no crime. I'm aware of the meaning of mens rea. What I'm not aware of is why you're not questioning your witness. So I'm going to introduce them as evidence, and then he defines defamation for the judge at the sidebar on day 9 of trial and cites case law to her. Oh my God. This is why the judge was so annoyed. This is the shit that was going on at sidebar. So defamation, we focus a lot on falsity, but the words also have to be defamatory. And the Shiner case, Virginia Supreme Court case 290 VA 83, says that defamatory words, you have to have the defamatory staying. Defamatory words are not those tending so to harm the reputation of another. Is he reading this off of his compendium, or does he remember this? Rottenborn. My guy, do you have a photographic memory for case law? What is happening? Is there a note? Does his compendium have a note in the binder? You guys are asking, does that count as mansplaining? Lawyer-splaining, because female lawyers do this too. When they're trying to win. But does he have this memorized? He's quoting the case. Defamatory words are those tending so to harm the reputation of another as to lower him in the esteem of the community or to deter third persons from associating with him. This is a fair point, Rottenborn, but I need to know how you have this on hand. How do you just have this ready to go? I need to know. But here's why it's a fair point. The fair point is that if you've already wrecked yourself, you can't be defamed. So has your reputation already been so shit on that you can't be defamed anymore because you did this to yourself? You have already wrecked yourself. Just think of someone whose reputation is absolutely the crappiest of the crap, and then be like, if you say something about them, will it lower their esteem in the eyes of the community? Or is it already so low that it's beyond hope? So it's a fair argument. I just don't think he needs to quote the whole case. He could simply have said, Your Honor, these are coming into evidence because his reputation is already so tarnished that he cannot be defamed. I'm thinking of YouTubers. Can Jeffree Star at this point be defamed, or has everything already been said? Can Amber Heard be defamed, or has everything already been said? Kitty's saying he read it from a big book. I was going to say, there are some lawyers that have photographic memories like this. I can't. Chat, I'm going to have to turn the chat off in a minute. Y'all are so fucking funny tonight. Defamed. I'm going to live forever. I'm living for this. All right. So he's trying to argue that Johnny Depp's reputation is so shit that it didn't matter what Amber Heard said because it's already done. Like, you already are wrecked. So get wrecked. And he says, and then they go on to describe the nature of that. The court says, quote, we have stated that defamatory language tends to injure one's reputation in the common esteem of mankind. To throw contumely, I don't think I've ever seen that word in my life. Ever. To throw contumely, shame, or disgrace upon him, or which tends to hold him up to scorn, ridicule, or contempt, or which is calculated to render him infamous, odious, or ridiculous. Loki. So this goes directly to elements that they have to prove in order to win this case, that not only were the statements false, but that they have the defamatory sting. Good way to describe it. And so the fact that all of these articles, a drop in the bucket, that these were out there, what I propose to do is get him to admit that this headline is not hearsay. It's for his reputation, what the public knew, whether true or not. And I just like to go through them. So that's why I gave them all to him at once, so we could move expeditiously through this. Well, thank you for being mindful of the court's time, Mr. Rottenborn. I will say one of them is a headline or the subject of the UK suit. I don't plan to emphasize that. The court, I don't see how they can get into evidence if you maybe ask him. Right, because they're not authenticated. Mr. Rottenborn, I'll ask him about it. I don't need to get them in, but I would like to go through and get him to acknowledge. Well, I'm sure you would like to. I'll ask him about it. I don't need to get them in, but I would like to go through and get him to acknowledge that as of this date, an article was written that said why. And if they don't come into evidence, that's fine at this point. I think they'll be very relevant under that case. Does this page follow? Oh, under that case, it goes to the heart of what he has to prove. I think in the future, the example I might use for reputational people is probably Jeffrey Epstein. Like, is there anything you can really say about Epstein, though deceased, that would damage the reputation were he alive? I think that's maybe an easy example to go with. Could you say anything worse than what's been said and proven? So, let's go. Ms. Myers. Your Honor, most of these articles have absolutely nothing to do with the defamatory statements that were made in the op-ed, which is that he was an abuser of women. These are completely irrelevant. The chat was already on that train of thought. The chat's like, right, but articles about, you guys are like Weinstein and Maxwell too. Yeah. Yeah, we'll do that. Or R. Kelly. Fair. You guys have given me good examples. Thank you. I try not to go to the guy with the little mustache. No. We don't use that in this example. But I think we've got some. Oh, don't use Epstein. YouTube will demonetize the video. That's fair. All right. Your Honor, this is what the chat just argued. Most of these articles have absolutely nothing to do with that. Mr. Rottenborn, doesn't matter. Actually, it does matter. It does matter. It does. Prince Andrew. Chris Brown. Oh, Chris Brown's also a good one. You guys have all the good things. Oh, Larry Nassar is another one that's good. Mr. Rottenborn, doesn't matter. It's so dismissive the way he says it. I can see him saying it. Doesn't matter. It wasn't me. Doesn't matter. It does matter. Because his reputation for being a abuser, alleged, being defamed by being called an abuser, is very different than people saying, this dude sure drinks a fuck ton. does drugs, shows up late to set, and assaults hotel rooms. Very different. Very, very different. Mr. Rottenborn, doesn't matter. Ms. Myers, this goes to a completely different aspect of reputation that's not at issue in this case. Mr. Rottenborn, doesn't matter. Its reputation as a whole is what the Supreme Court says that you look at. Quote, or intending so to harm the reputation of another as to lower him in the esteem of the community. When you look at these articles, something by Miss Heard saying 2 years ago I became a public figure representing domestic abuse is a lot less likely to have any impact. The court, but this one doesn't come in. You can't ask him about this one. Mr. Rottenborn, okay, I won't. The court, I have to go through these separately. The court's like, fuck. Now I have to go through it all differently. Ooh, Murdaugh's the new example. Murdaugh and James Spears. There we go. James Spears and Murdaugh. Yep. That. Let's see. Mr. Rottenborn. The court's like, I have to go through these. Your Honor, I mean, the headlines themselves are hearsay. They lack any foundation. I mean, some of these are tabloids. Mr. Rottenborn, they're not hearsay. They're not being offered for the truth of the matter. Well, but they are being offered because you're saying they ruined his reputation. I agree. Mr. Rottenborn, I know, but it's something that says apparently Johnny Depp was drunk. I don't care if Johnny Depp was drunk, but if that's out in the public, that's directly relevant to his reputation. Oh, Mr. Rottenborn cares very much if he was drunk. Were you there? I'm not saying that they prove something. I'm saying that the public knew and that these were out there, and that's under the Shayer case. That's the heart of the case, Your Honor. If he had been someone with a crystal clean record who had never had any negative press about him, he wouldn't be a celebrity. Whatever's being sued, whatever statement is the subject of the defamation case is going to potentially carry more defamatory sting than someone who's had all of this stuff written about them. Ms. Myers, Your Honor, an article does not establish that someone's reputation is the court. It's out in the public because he's a public person, so I understand that. I'm just seeing which ones of these are cumulative. Good for the court. It's out in the public because he's a public we did that. Rottenborn, that one that you're looking at, all right, the court, none of them come into evidence, but you can ask him about them. Mr. Rottenborn, thank you, I'll take that out. Run away, Rottenborn, you got the ruling, you run. Be done. Mr. Rottenborn, yes, nothing more. The court, and the dates, I assume, Mr. Rottenborn, and yes, the dates, Your Honor. The court, the date of the op-ed again, Mr. Rottenborn, December 18th, 2018. The court, I think we already did this one. Mr. Rottenborn, we did, I'll take it out. The court's catching him being sneaky. Rottenborn, we already did this. The court, you want to see the ones? Mr. Rottenborn, yeah, okay. So she's saying these are the ones you're allowed to talk about, I think. The court said, if you want to switch stacks with me, Jesus. Stacks of defamation. Lisa said, contumely, which I can't even pronounce. Insolent or insulting language. I have only ever heard this word in Hamlet. This case law is probably from then. This case law is probably that old. Stacks of defamation. Sorry. If you want to switch stacks, I'm never going to be able to say the word stack again. Literally ever with a straight face. Like literally ever with a straight face. Never. These are Rottenborn stacks. Somebody said better than stacks of defecation. That's true. If you want to switch stacks with me, I can. If you want to make sure, Mr. Rottenborn, sure. The court is so pleasant with them. You might take a look at what I have, Miss Myers. Thank you, Mr. Rottenborn. I'm just going to set these to the side, Miss Myers. I would maintain my relevance objection. The court, it's reputation of a public person, so that's out in the public. They're not coming into evidence, but he can question about it, and you can redirect about it as well. But I just want to make sure, Mr. Rottenborn, Your Honor, with this one, I would propose to read the title, but then the subtitle as well. The court, okay, that's fine. Myers, can I see the subtitle? Can I see the subtitle? Mr. Rottenborn, after this, I only have one little module and then I'm done. What module, sir? The court, okay, thank you. Mr. Rottenborn, thank you, Your Honor. Can I get that back from the witness? Maybe it might make sense for me to. The court, that one, you can take mine if you like. Rottenborn, okay, I think there were only 4. I can just take his out real quick. Okay. Mr. Rottenborn, do you want to give these to the witness, please? And then this has the full set. The court, okay. So this is them actually going through the paper. The court, that's fine. Thank you. Back in open court. So I love, it needs to be noted they're back in open court. And then he's asking, Mr. Depp, if you could please take a look at the stack of articles in front of you. Yes, it's a stack of, I think this was hit pieces generated by Miss Heard's publicity team. Mr. Depp, we're going to get through this as quickly as possible. Oh, the fuck you are. You would sure like to, Rottenborn, but Johnny Depp's like, nah. I'm just stating what they are, sir. Well, we're going to talk about them. The first one is entitled, it's from The Guardian. Do you see that? Apparently drunk. Yes. Yeah. And this is an article from November 15th, 2014, entitled Apparently Drunk. Johnny Depp cut off at Hollywood Film Awards ceremony, correct? That's what it says. Yes, sir. And the next article is an article from May 7th, 2016. It's entitled Johnny Depp, Friends and Family Seriously Concerned About Him. Here's why. Yes. How did they know? The next article, May 1st, 2017. Yes. Before Miss Heard filed for restraining order a year and a half before she published. No, sorry. This would be after May 1st, 2017. The headline, Johnny Depp has a clear and epic sense of entitlement, ex-managers say. Yes. The managers he was in a lawsuit with. I wonder. That was in the Hollywood Reporter, correct? I was in a lawsuit with them. So, oh yeah, keep reading. That kind of makes sense. I was in a lawsuit with them, so yeah, they're gonna say that. Oh, now you guys are talking about steak stack. I want some steak and shake. I wonder what time they're open till. Okay, stop. I'm getting distracted. I was in a lawsuit with them. So the next article from May 10th, 2017 is entitled Johnny Depp, a Star in Crisis and the Insane Story of His Missing Millions. Did I read that right? Yes. That's straight from the same lawsuit, sir. The next article, also from May 10th, 2017, a year and a half before the op-ed. Johnny Depp reportedly drank heavily and was constantly late on new Pirates movie set. Did I read that right? You did. Reportedly. It's very quick-witted, actually. The next article, also from May 10th. This is a pathetic attempt. Ooh. It's reading it back. It's got different sass. Mr. Depp, please just respond to the question I'm asking you. What's your question, sir? Mr. Roddenborn. The next document, an article published in Vanity Fair, May 10th, 2017, yes, sir, is entitled Johnny Depp's Financial Woes Might Sink the Next Pirates of the Caribbean. I think it's fair to ask some of these. I do, because I understand what they're trying to argue. And I think that when you have redirect, you get to the heart of these things without it being a huge issue. So this was getting to, did Amber Heard open the door to talk about these things? And then we got very far afield talking about the sidebars, because why not? All right. Let's look at the motion to seal the juror identities. That's the next one up on my list. And we will do that right now. All right. Look at that. It just all worked. All right. May 16th, 2022. Plaintiff John C. Depp's memorandum in support of, that's the wrong one. Wait, where'd it go? I want this one. Why didn't it pull up this one? Because I'm pulling up the wrong one. Let's see. Oh, because I linked the wrong one. Hold on. We got to get back. We got to get back in time to my drive so we can get to the right one. Sorry, y'all. Give me just a second. I thought I had it pulled up, but no, I just repasted the same link twice. And I planned on talking about it, so we can't move on, which is unfortunate, but you know, it is what it is. Let us. We'll find it. Where is the jury memoranda? Not that one. Not that one. That's so. Now we have to find it. It's got to be later in time. Seal the identities of the jurors. Found it. Yay. That didn't work. Why didn't that work? Sorry, y'all. We're getting there. WAP. This is a WAP. This is a WAP moment of when I think I've got everything prepped, and then it takes a moment. WAP. Defendant and counterclaim plaintiff Amber Laura Heard's motion to seal records relating to jurors' identities. I like that just identities is underlined. Identities. Identities. Let's see. Defendant Heard moves to seal records relating to jurors' identities for 1 year following the conclusion of this trial for the reasons set forth below. This is what I wanted to see. I really wanted to see what the reasons were behind this. I'm so curious. I'm so curious. All right, Naked HD, I'm so glad you took the time to subscribe to the channel, but you are yeeted. The First Amendment provides, always with the First Amendment, always with the First Amendment. The First Amendment provides a broad but not unlimited right of access to criminal trials and trial-like proceedings. The Supreme Court in Virginia recently held in Ray Bennett that the qualified right of access to proceedings that applied in criminal cases should also be recognized in civil trials. And let's see, the court articulated the following two-part test for determining whether certain records or proceedings are protected. Well, okay. First, we'll examine whether there has been a history of public access to the records and proceedings. If such a right of access exists, the proceedings or records are presumptively open to the public. Under the second part of the test, proceedings can be closed or records sealed if closing the proceeding or sealing the record is necessary to serve a compelling interest and is narrowly tailored to serve that interest. This is where the arguments are in the Britney Spears case about not narrowly tailoring the, like, turning off the entire remote audio access program. So these First Amendment arguments. Let's see. When assessing the first prong, the courts look to, okay, that's the legal standard, but what's the argument? That's what I wanted to know. There is no long-standing history of public access to records relating to identify the jurors. There's no long tradition of openness, they're saying. But why? Furthermore, several federal courts have approved the use of anonymous juries. Holding anonymous jury is permitted when, among other things, there's a strong reason to conclude that the jury needs protection from interference or harm, or that the integrity of the jury's function will be compromised absent anonymity. Yep. I think that's going to be more and more and more true, unfortunately. I really, really think that this is going to become more of a problem in the age of much more accessible information about people and the potential for threats, for doxing, for public interference with jurors. I hope that that doesn't happen, but I think that we will see lawyers being mindful of keeping jurors protected so that they are not influenced by public opinion. I think that's a huge problem, especially with an unpopular defendant. I mean, when you look at a case like the Kyle Rittenhouse case, so many were outraged at the verdict of that jury. I can imagine the court wanting to go to lengths to protect that jury from being doxxed, from being harassed at work, and that kind of stuff. So let's see. A district court may impanel an anonymous jury in any case which the interest of justice so require. In some, while disclosure of jurors' identities is common, such disclosure is far from ubiquitous. But why? Sealing records relating to jurors' identities serves a compelling interest. What? If the court concludes, but what's the compelling interest? Okay, good. Here, sealing records relating to the jurors' identities is warranted in light of the serious risks that jurors will be threatened and harassed. Fair. People covering this case have been threatened and harassed. But I do it on a public platform and I choose to do it. I'm not getting called to jury duty. I'm not getting dragged in by the long arm of the law to do this. Let's see. In light of the serious risks that jurors will be threatened and harassed. Since the beginning of the trial, Ms. Heard, her counsel and public relations firm, and witnesses faced harassment by the public. And as of others. But what I will say is, since the verdict came back, so this was filed before the verdict came back. Since the verdict came back, I think the only one harassing the jurors is Amber Heard and her legal team, besmirching their work and calling them out. I think the only one harassing them is this, is Amber Heard's team. I think the harassment is different. Let's see. A tweet reported that there is a website offering $1 million to kill Ms. Heard and her counsel. That's fucking abhorrent. But also, is there veracity to it? A tweet reported that there is a website. Elaine, if that is true, that's fucking abhorrent. But did you go and see the website? And if you saw the website, did you report it to, I don't know, the police? Like, putting a bounty on someone's fucking illegal, and it seems like something they would maybe take aim of. But if it's just some rando account, and yes, I use that word carefully, saying, I heard there was somebody doing this, it's different. Like, we need the receipts on that, because it doesn't say a tweet shared a website. This says very specifically and carefully, a tweet reported that there is a website. During her testimony, Dawn Hughes's WebMD page was inundated with negative reviews. She wasn't the only one. They actually attached. Why didn't they attach the tweet? They're capable. Why not attach a screenshot? Why not? After Dawn Hughes testified, she received multiple death threats and emails and voicemails. Cybersecurity agents for the Department of Homeland Security are investigating these threats. No one should be threatening Dawn Hughes. It's absolutely okay to criticize her testimony as being deeply and inappropriately gendered. That's fair. Criticize her all you would like. Do not threaten to kill her, and do not leave fake reviews, because if you haven't been treated by her, they're fake. Not okay. But I did want to know what was going on, and now we get to know. So there we go. Ms. Heard's counsel law firm has been flooded with numerous false negative reviews, resulting in the filing of an abuse report with Google. I'm not surprised. In addition, Ms. Heard's counsel's law firm was so harassed by calls that it had to set up a media relations voicemail box for calls about this case, and has blocked multiple phone numbers. Y'all had to block phone numbers? How did they not see this coming, though? I wish they had known in advance. Like, how did they not know? Oh, hubris. They thought they were going to win this case. They thought it was a slam dunk, and they thought everyone was on their side because of what happened in the UK. Well, they overplayed that. People shouldn't be harassing the law firm. They shouldn't be calling the law firm. They shouldn't be leaving voicemails and emails at the law firm. If you haven't worked with this law firm, you shouldn't be leaving reviews. Leave the criticism to criticism. Don't harass and threaten and stalk. It just lends credibility to these people feeling like they're victims when they're not. Because then they become victims. Amber Heard's counsel law firm has been flooded with numerous false negative reviews, resulting in the filing of an abuse report with Google. In addition, Ms. Heard's counsel law firm was so harassed by calls that it had to set up media relations voicemail box for calls about this case. I wonder what came in through Depp's. And has blocked multiple phone numbers from which the firm received calls. It's like Dr. Spiegel's, like 3 mean phone calls. I got mean phone calls at my office. Ms. Heard's counsel have been repeatedly harassed, including receiving virtually nonstop calls to their personal cell phones, both in the middle of the night and during trial. That's fucked. Don't do that. See Exhibit A, call log of counsel's personal cell phone showing 12 calls from 11:54 a.m. to 12:43 p.m. on May 4th. That sucks. Don't dox the lawyers. Heard's publicist, who oversees Ms. Heard's public relations, recently received death threats. Her publicist intends to file a police report of the threats to the LAPD, as they should. Mr. Depp has interacted with fans on courthouse grounds, which has been posted in social media. There's a TikTok. These interactions have fueled the fire of Mr. Depp's online army of supporters. Oh shit, here we go. Furthering the harassment. Oh, so this is just them bitching about Johnny Depp. You guys are mentioning that worse was done to Tug, that umbrella guy. These interactions have fueled the fire of Mr. Depp's online army of supporters, furthering the harassment. If the public learns the jurors' identities, they are likely to face the same harassment and intimidation. They thought they were going to win. And as the court and Morgan observed, waiting until a juror is actually threatened is too late. I don't disagree with that. Thus, the court should maintain the sealed status of records relating to the jurors' identities after they reach their verdict. Unsealing these records when the jury is released will thwart the purpose of protecting their identities during the trial, because jurors are most likely to face retaliation immediately after the trial concludes. I don't think that would have happened in this case. Additionally, the court should inform the jurors before they begin deliberation that their identities will be sealed. Waiting until they reach their verdict could prove prejudicial to Ms. Heard. Oh, so they were concerned the jury might be swayed by public pressure and might be worried. So they were like, oh, the jury might be concerned, but if we tell them it's sealed, they're more likely to rule in favor of Amber, because if we let them know they're protected, then they might feel like they can go against public opinion. I think that's a fair argument. Additionally, the court should inform the jurors before they begin deliberations that their identities will be sealed. They think this is going to help the jury rule for her. They didn't. Waiting until they reach their verdict could prove prejudicial to Ms. Heard. They know it's unpopular. While Ms. Heard does not doubt the jurors have done everything they could to avoid media coverage of or discussion about this lawsuit. Oh, you do? You do? You fucking do? I'm sorry. I'm going to choke on my words right now. While Ms. Heard does not doubt that the jurors have done everything they can to avoid media coverage of or discussion about this lawsuit, the coverage is everywhere. When did you start doubting it? When they found against you? Is that when you changed your mind? Because this is an illegal filing. Changed your mind? Between the verdict and Good Morning America or whatever? Even if they have read or heard nothing substantive about the case, the jurors have seen a courtroom filled with Mr. Depp's partisans every day who snicker at Mr. Depp's courtroom conduct and who fill the public courthouse hallways and grounds. The jurors must navigate to do their job every day. That sounds awkward. The jurors should be able to deliberate free from fear of looming harassment or intimidation, regardless of the verdict they reach. So they're still hopeful that they're going to win, and thinking that the reason they might not win is because the jurors are afraid of Johnny Depp stands. Accordingly, the court should seal the records of the jurors' identities. During this time, the media attention this case has garnered will abate. During the year, the media attention this case has garnered will abate. Well, we sure fucking hope so, but you keep doing all the things. And the public's passions about this case will subside. It will. Thereby greatly reducing the risk of harassment to the jurors. I hope so. For the foregoing reasons and the reasons stated in oral argument, Ms. Heard requests the court seal the records. I don't think it's the wrong thing to do. I don't think it's the wrong thing to request. I'm glad they redacted it. I think that's really unfortunate that people were getting her attorney's personal cell phones. It's such an invasion. It's just that shit's fuckery. Elaine is so bothered by what people are saying about her on TikTok and shit. Just do that. Just put it on social media. Say what you have to say. Don't threaten. Don't harass. Do not call. Ugh. Laura J.S., you ask a good question. How would they seat a jury for an appeal? Juries don't deserve the appeals, or juries don't decide the appeals. The court does. Sorry, I was reading Katie's comment as my mouth was talking. My brain was reading this. It's disgusting behavior. So, no, it's decided just by judges on the Court of Appeal, and it's decided just on the record. The courts look at the record and they decided on the record. That's the thing I was really most interested to see tonight was what they decided, and this is what they decided. But Your Honor, we protected their identities. And then they didn't do what we want. So then we started blasting them in the media. And then we started putting them in our motion so they would be more identifiable to blast them. We very much cared about them before they ruled against us. It's just, yep. Let's look at, oh my goodness, we're almost 2 hours in. All right, what time is it? Let's look at the motions regarding the medical examinations. We might not get to all this tonight because I am moving slow, but I'm deeply, deeply interested. Wait, take a look at those calls again. It was 12 missed calls over lunch, not at night. Wait, what? Y'all are faster than me. Could that be her office? So 11:54 a.m., 12:03 p.m. Wait, what did she say in the motion? She said middle of the night, didn't she? Oh, no, she said it. But she said both in the middle of the night and during the trial, call log of counsel's personal cell phone calls showing 12 calls from 11:54 a.m. to 12:43 p.m. No, she characterized both, but she didn't give anything from at night. She said at night and during the trial. But how do you know? How do you know? Hello, passenger shaming. Good to see you in the chat. How do you know it's not your office? Yeah, the chat's the smartest chat on the internet. That's why we do this live. So I have the benefit of all of y'all's brains. I mean, there's over 26,000 of you across platforms here. Don't forget to like and subscribe. But they're in 2020, not during the trial. It doesn't, I don't see it saying when they're from. How do y'all think they're from 2020, not 2022? Yeah, the date was 2 years late. SK, thank you. Great audience. I don't see the date. Where did y'all see the date? I only see the missed calls. Oh, let me see. Did it say it up here? Oh yeah, May 4th, 2020. That might actually be an Elaine typo because she didn't actually put the date in there. That might be an Elaine typo because it says personal cell phone showing 12 calls from 11:54 to 12:43 on May 4th, 2020. I don't know. That might have been a typo, but if it's not, she's saying in the middle of trial, and this is definitely not in the middle of trial. The reason I think it might be a typo, A, we've seen other typos from counsel, and B, this was filed on May 16th. So anyway, we'll see. We'll see. It's interesting. It's on, yeah, it was in the statement of the body. Thank you all. So let's see what's next. Let's do the motion for sanctions next. Since we're talking about Elaine, let's look at if anybody's getting sanctioned, shall we? Sanctions are interesting. Civil attorneys throw this shit around like it's just like sanctions. They filed so many motions for sanctions against each other during this case. It was absolutely bananas. All right, motion for sanctions, March 11th, 2022, filed by Johnny Depp against Amber Heard's counsel, set for hearing on. We understand that this matter has been specifically set for a hearing on March 18th, 2022, before the Honorable Judge Penny Oscarati. Oh, that was just the date. Hold on. I liked the specifically set. You've specifically set time for this motion for sanctions. Let's go to the memorandum in support. For those of you asking if the text is blurry, some of these are not scanned well, and that is what the text looks like when I blow it up. So that is that. Let's see. Let's make this just a wee bit bigger on the bottom. There we go. All righty. Here's the memorandum in support of the motion for sanctions. John Depp is moving about it against defendant Amber Laura Heard based on her violations of the stipulated amended protective order. And now we get into the protective order. And the court's directive at the pretrial conference from February 9th, 2022, that the parties and their counsel do nothing to taint the jury pool. Damn it, now that we've had stacks, I can't say taint in the right headspace because we've already stacked this stream to my brain being in the improper headspace. As set forth below, defendants' egregious violations of the protective order and the court's directive have severely prejudiced Mr. Depp and have almost certainly tainted the jury pool. Argument. Ms. Heard's false rape allegation. Wow, we're going right there. Ms. Heard's false rape allegations constitute protected information under the protective order. Yeah, they are tainted stacks. It's kind of like tainted love, but worse. Tainted love. Sorry, y'all. It's a Friday night. As Ms. Heard's counsel knows perfectly well, the highly sensitive rape allegations by Ms. Heard are indisputably protected information under the protective order. Here's what I'm looking for while I try to regain my seriousness. Here's what I'm looking for. I believe when Elaine brought up the allegations, particularly the information about the bottle, in her opening statement, it also violated this. I want to see the protective order because it's my understanding that the protective order would have made it so that Amber Heard did not have to make this testimony as public as it was made. So when Amber Heard goes on TV and is like, no one should have to testify in public like that, I think they did it to themselves. I think there was a protective order that would have been protected information, but then they fucking violated it to get that information out into the public. And that's why that testimony was then made public instead of that testimony being before the jury only. They could have very realistically put that testimony and segmented that testimony away, saying we're going to ask all these questions, and then either at the end of the morning or at the beginning of lunch, saying we're doing this testimony a bit out of order just for the jury and clearing the courtroom out. No observers, no one else. Clear the courtroom, just the jury and just the attorneys, and then have that testimony still be protected. They could have done that, but if the protective order got violated, that's why they're not going to do it. Neil Wilcox, this is such a generous super chat. Thank you so much. Thank you for your efforts, hard works, and expertise on the subjects you comment on. I'll always tell you when I'm not. Your approach of facts, not fuckery, is greatly appreciated. Thank you for your POV. Thank you for your commentary. Thank your support system, and thank you for being you. You are welcome. I always thank my support system. We definitely need them. I appreciate you, and thank you. Let us continue. I want to see this. I want to see this. As Ms. Heard's counsel knows perfectly well, the highly sensitive allegations by Heard are indisputably protective information, and I am going to censor myself a little bit just to appease the YouTube gods. Thank you, YouTube. Oh, thank you, YouTube, for not throttling my stream. I mean, there's almost 30,000 of us here. We're not throttled yet. The protective order in the case on June 21, 2021 specifically addressed the SA allegations that were directed by the UK court to be sealed and agreed by the parties to this action should be maintained under seal as specified in paragraph 3A IVVI on pages 3 and 5. See Exhibit A. Ooh, good. Ooh, good. Ooh, good. For Ms. Heard and her counsel to maintain otherwise is untenable and absurd. Defendant violated the notice requirements in paragraph 12 of the protective order. Paragraph 12 states in pertinent part as follows: the parties may in good faith disclose protected information at any hearing if it relates directly to the subject matter of the hearing and after prior notice to the court and counsel and an opportunity to object. You can't just say that shit out loud. You have to tell the court and counsel this is coming up. We need to talk about it. And then the court and counsel can decide how to deal with it before you say it on the record in front of whoever's sitting in the courtroom. Like God and them. This is T. As set forth below, Ms. Heard's counsel violated paragraph 12 in at least 3 material respects. Her 5 references to the allegations did not relate directly to the subject matter of the February 25th hearing. Ooh. She gave no prior notice to the court. She gave no prior notice to Mr. Depp's counsel, and who therefore had no opportunity to object to its use, which we most certainly would have done. Well, shit's already out of the horse on that one, Ben Chu. Whether Bretta Hoft knew that a reporter was in the courtroom is a total non sequitur. You can't state that shit in open court, regardless of who the fuck's in open court. This is Emily opinion. Unsealing this shit shows the level of fuckery they were up to before trial and during trial. No wonder they didn't want it unsealed. Because this shows the underhanded manner that things were being done. What matters is that she knowingly violated each of the 3 threshold criteria of the protective order for disclosing protected information and that it resulted in serious harm to Mr. Depp, the precise harm those provisions and the protective order as a whole were designed to prevent. And Ms. Heard and her counsel knew that the whole purpose of amending the original protective order was to protect these precise allegations, which are the most scandalous and prejudicial. Moreover, Elaine's references to the allegations also violated the court's directive from February 9th, 2022 at the pretrial conference not to talk about the case and thereby risk tainting the jury pool. The court. I would hope I wouldn't have to say, the case will be tried in court. We have got the jury pool. Like I said, we're going to be sending out jury summons soon. I would hope that we don't taint the jury pool by talking about this case prior to it happening on April 11th, correct? We're all in agreement with that, right, Mr. Chu? Absolutely, Your Honor. The court, okie dokie. It's like, we binged. Thank you for subscribing. We're at 665. Oh, we're rolling towards 666, y'all. When the court has to say, we agree, right? Correct? It's like when you ask your partner, this shirt makes me look good, right? The only correct answer is, awesome. Love it the most. It's perfect. Yeah, Judge A said okie dokie. She's sure. I wanted an artichoke after that too. The court was like, okie dokie. I need to look at where it did. I need to know if Judge A went to like school. Is she from the Midwest? I feel like this is such a Midwestern statement. Okie dokie. Don't you know? Anyway, I love it the most. She has a Winnie the Pooh backpack. Like, come on. Judges are humans too, and I think Judge A showed us a lot that judges are humans too. Okie dokie. The timing on this was so fucking flawless. Oh, we get to see the transcript, Exhibit B. Can't wait. Ms. Bredehoff's purposeful references to Ms. Heard's false and outrageous allegations or essay violate the protective order and the court's directive not to taint the jury pool. As the court will recall, the sole purpose of the February 25th, 2022 hearing was for the court to ascertain the party's position on whether a pool camera should be permitted at trial. T. So the February 25th, 2022 hearing, Exhibit C, transcript, was about whether or not there would be a camera in the courtroom. Ooh, bitch. It's going down. I'm yelling timber. Rather than answer the court's straightforward question, Ms. Heard's counsel launched into a non sequitur about a divorce statute, at which point the court cut her off, reminding counsel that this is a defamation case, so Virginia's divorce statute does not pertain. Nevertheless, Ms. Heard's counsel ran the stop sign and bulldozed ahead, this time going still further afield, referencing the statute relating to victims of SA. Then Ms. Bredehoff repeatedly disclosed in open court the most explosive protective information imaginable. Ms. Heard has alleged that Depp SA'd her, including rape on several occasions before and during her marriage with Mr. Depp. Here's why I said fuck it. Because you know what? I try to parse my words, but I don't want to discount the seriousness of these allegations, not for Heard, but because it happens. And if we can't talk about illegal things that happen when we're not doing it in a salacious way, we can't talk about real shit that impacts people. So my brain was just like, fuck it, we're just saying words. That's what's happening. That's why we have a community. We can say words because these things happen. The jury found not to her, but these things happen. Exhibit C contains all cited pages of the February 25th transcript hearing. Yes, they do. Since Ms. Heard is a victim of SA and rape, her testimony as a victim would be excluded under the status. Now Mr. Depp's complaint alleges defamation on the basis that Ms. Heard alleged that she was a victim of domestic abuse and sexual violence, which he has contended is referring to Mr. Depp. That's the headline. Exhibit C. They found 12 acts. Oh, this goes to the UK court. They found 12 acts of domestic violence as well as sexual violence against Ms. Heard. Putting Amber Heard, who is a victim of sexual violence, on camera to discuss these rapes and these sexual assaults along with the beatings is not what the legislature intended, and that's why they prohibited under 19.2-266. Okay, here's the thing. I think that Elaine should have made these arguments, but I think she should have abided by the court's protective order and said to the court, to argue against pool cameras effectively, we need to talk about the allegations that are being made. And I can't argue against the cameras being in the courtroom if I can't bring that up. So I have to bring that up. And I think that she's making the right argument. She had to argue this for her client, but she didn't have to violate the protective order to do it. She just had to give the judge and counsel a heads up. This is my argument. They know. It's not like it came up out of the blue. She went to this hearing knowing that it was a hearing about a camera in the courtroom. She knew this was the argument she was going to make. This is willful and underhanded, and it undermines work that could have been done. It's a fair argument that there is certain testimony that shouldn't be on TV. Fair. But if there's a protective order, fucking abide. Miss Heard and her counsel violated the protective order, the PO by disclosing five times the most explosive protective information conceivable, which Ms. Bredehoff was explicitly told by the court before she made the improper disclosures of the PI that they in no way related to the issue of hearing pool cameras, failing to provide the court prior notice. She had every opportunity to provide notice. Every opportunity. And didn't do it. I understand, though, why she wanted to make these arguments. Like, I get why she wanted to make the arguments. I get it. And I actually think she's right that the issue does relate to whether there should be cameras in the courtroom. I do agree with her that the issue does relate, but we'll have to see what the court says. Okay. Let us continue on. Again, Elaine made her fifth improper disclosure. The court repeated, I do not read section 19.2-266 that way, and overruled Ms. Heard's objections to the cameras. Their wrongful disclosures also almost certainly tainted the jury pool. Courthouse News Service immediately reported that Ms. Bredehoff's repeated disclosures of the protective, scandalous allegations. I need to subscribe to Courthouse News Service. Within only a few hours of the February 25th hearing, Courthouse News Service blasted the following headline: Attorney says Heard was raped during her relationship with Depp, Exhibit D, emphasis in original. In the most unlikely event that any reader missed the point, the reporter Joan Hennessy stated in the first line of the article, Fairfax, Virginia, actress Amber Heard once described herself in a Washington Post op-ed as a public figure representing domestic violence, but in a Virginia courtroom Friday, her attorney spelled it out. Heard, the attorney claimed, was raped while the partner of actor Johnny Depp. The potential impact of Elaine's wrongful disclosures of protected information on the jury pool can hardly be overstated. The author, Ms. Hennessy, approached counsel for Mr. Depp as soon as he left the courtroom, stating that she had never heard about any of the rape allegations, which she stated were not part of the pleadings. Indeed, Ms. Heard manufactured a false claim long after the TRO and divorce case, when she would have every incentive and reason to raise them. Bound by the court's directive at the February 9th pretrial counsel, Mr. Depp's counsel could not comment, and the article, which was published throughout Fairfax County, and the jury pool. And the article, which was published throughout Fairfax, fine. Defendant's violations severely prejudiced Depp. By violating the PO and the court directive, Heard caused the most explosive protected information to be published to the jury pool, thereby tainting it. In so doing, Heard and Bredehoff deprived Depp of being the first to bring this scandalous charge to the jury's attention in my opening argument. Now at least some jurors are likely to have heard defendant's false version first, which puts Mr. Depp at an enormous, perhaps irrevocable disadvantage. The court should take away Ms. Heard's 5 peremptory strikes and impose monetary sanctions. Paragraph 23 of the PO provides that the court wide discretion in the event of a breach, including any remedy to which they, the parties, may be entitled in law or equity. See Exhibit A. They're saying take away all of the defendant's peremptory strikes. They only had 5. That's not a lot. The peremptory strikes, real quick. The peremptory strikes are when the attorneys get to say, Your Honor, please thank and excuse juror number 4 for whatever reasons. And not excusing them for cause, just excusing them for a legally proper reason. You can excuse jurors. So they're saying, no, you don't get to excuse anybody. Fuck you. You're stuck with the jury that you got, which could put a team at a big disadvantage. Barr misheard from mentioning or introducing any evidence of her claims against Mr. Depp at trial. Yeah, that was never going to happen. Impose a sanction of $25,000 to reimburse Mr. Depp for having to litigate defendant's multiple violations. Order such other further relief as the court deems proper. Let's get to these exhibits. Here's the protective order. The parties anticipate this action will be tried in April 2022. We know the background of the action. We know the judgment from the UK. We know how, so they're talking about how it's going to be designated. Oh, this font. Nothing in this amendment shall be construed to limit or restrict the party's right to apply, to vary, to change, amend, or terminate the confidential status of documents in Section 3A VI 6 by written agreement or application to the U.S. court. Protective information shall mean confidential information. And then they talk, should protected information become part of the public domain without any violation of this order, such protected information will no longer be subject to this order. Producing party shall mean the party who has produced it. Receiving party, we know that. We know how to designate it as confidential. So this is the PO and goes through, let's see. Except with prior written consent of the producing party, the person who gave it over, or by order of the court, confidential information shall not be furnished, shown, or disclosed to any person, entity, except to the parties, counsel of records for the parties, and their associated attorneys, including Adam Waldman, who has already seen the documents deemed confidential by the UK courts prior to the date of this amendment, and who shall sign Exhibit A before being provided any additional information, paralegals, other professionals. This is a kind of common protective order. Like, you can show people who need to see it for work, but that's it. Work on the case, not like reporters and stuff. Let's see. In good faith disclose. All right, there's not a ton of detail about the information other than it's information that's already been deemed confidential. So I'm going to zoom past this real quick. And when I do a more detailed deep dive, if there's anything else in there, I'll pull it out. These are the consents to the protective order. I wanted to look at the hearing transcripts. Hearing transcripts. Hearing transcripts. Wednesday, February 9th. Elaine's in court. Nita Houghton is in court. Let's see. Who else is in court? Ben Chu's in court. We're starting on page 50. Court reporter, can I ask you to move to the microphone, please? Mr. Chu, yes, apologies. Ms. Bredehoff, so in the security procedures, Your Honor, I anticipate that the parties will have some security detail coming in and out of the courthouse, the court, and we'll talk security. I was going to keep that under seal, though. Ms. Bredehoff, okay. Right, because you don't want people to know your security plan. The court will get to that. Do you expect your clients to be here every day of the 7 weeks? Bredehoff, yes, Your Honor. Chu, yes, Your Honor. The court, okie dokie. So we'll definitely talk about that and figure out what we need to do. Let me see. All right. I would hope I wouldn't have to say, the case will be tried in court. We have got the jury pool. Like I said, we're going to be sending out jury summonses soon. I would hope that we don't taint the jury pool by us talking about this case prior to it happening on April 11th, correct? So this is the judge saying, y'all, STFU. We're all in agreement with that, right? Correct? Right? Mr. Chu, absolutely, Your Honor. The court, okie dokie, all right. Ms. Bredehoff, and Your Honor, on that voir dire, she doesn't agree. They don't get the agreement of Elaine. Mr. Chu said absolutely. Elaine might have been nodding in court, but she doesn't she doesn't affirm it on the record. That might be a nothing burger, but that's interesting to me. Ms. Bredehoft, Your Honor, on that voir dire, just thinking it through, and I know we can talk later too, the court, sure. But it seems to me that if we try to do taking them individually, that might draw things out. The court, take a long time. Bredehoft, yeah, pretty extensively. The court, I mean, we can take them by tens. We can take them by however. The only issue I have is I see sometimes in these cases that are lengthy causes is that if somebody hears one excuse, somebody else might join in the excuse. It happens every fucking time. It happens every time. It happens every time. Once you get people saying, but Your Honor, I've got this and that, the next person will be like, oh, Your Honor, I've got this and that. It rolls downhill like dominoes or I don't know, boulders or some shit. The court's like, this is what happens. Yep, it sure does. But the uniqueness of this case might be different. And then that is the end of that transcript. Let's see. February 25th, 2022. We're going to say all the words in this one. Let's see what page we start on. Page 3. Great. Ben Chu is in court. Elaine Bredehoft's in court. All right. Thank you. Let me just get Miss Bredehoft on the big screen for you, Mr. Chu. Good afternoon. Oh, so they're not physically in court. They're on court call. Good afternoon, Miss Bredehoft. Can you hear me okay? I can't hear you. Holy fucking shit. Elaine still doesn't have her mic on. Your microphone, Elaine. Good afternoon. Elaine, can you hear me? I can't hear you. Elaine, I was on mute. My apologies. Turn on your mic, Elaine. It's not just the microphone in the courtroom, y'all. For the love. I imagine this is Elaine on every Zoom call ever. That everyone's just like, your mic, Elaine. Your mic, Elaine. Your mic, Elaine. This wasn't just in court. I joked during the trial that she was probably like this on Zoom, and there the fuck she is on Zoom. I was on mute. I can't. Elaine. At least on Zoom, it gives you like the little red, you can see that you're on mute. Oh my God. I was on mute. My apologies. The court, there we go. Got you now. Now can you hear me? Yes, we can hear you fine. Can you hear me now? Yes, we can hear you fine. And Mr. Chu is in the courtroom. Interesting. They're local. I think Mr. Chu works in the DC office. They're local. There is an advantage to being in court if you could be in court. There's a huge advantage to being in court. Let's see. The court. All right. So I just set this hearing just to hear what your positions are on this matter, just because I have received quite a few different requests to have a pool camera. I bet you have. So I just wanted to know where the positions of the parties was. Mr. Chu, good morning, Your Honor. May it please the court, Ben Chu for Johnny Depp. This is my nightmare. Seeing multiple Miss Bredehofts instead of just one. Oh my God. I was kidding, Elaine. I thought I would defer to Miss Bredehoft to go first before. Okay, advancing our position. All right, go ahead, Miss Bredehoft. Did she have multiple screens on too? This is my nightmare. No wonder the court was just like, you're just a snarky guy, because the court's been through this for years. This is what the court did for years. Oh. No, I bet Ben Chu has some bite. I imagine Ben Chu in front of a jury is a sweeter, more affable dude than Ben Chu not in front of a jury. Ben Chu's got some bite. Jen's like, I'm laughing so hard, I'm afraid I will pee. Always me. You guys are scaring your pets. Don't scare the paw nerds. I mean, we're about to get into such a serious topic, but also this shit has been found to be defamatory, but this is just, it's just giving. After watching this trial, this is better being unsealed later. I'm just going to say it. This is better for our purposes being unsealed later because now we have context. There's no way this is funny before we watch 7 weeks, 6+ of Elaine. Oh my God, I'm dying. Wow, okay. Your Honor, I actually took a lot of time to go into this. Oh, you thought it out. You thought it out. Well, if you thought it out, you could have maybe mentioned to the court the shit that was going to come flying out of your mouth in violation of a protective order, maybe. Just saying. Your Honor, I actually took a lot of time to go into this. Great. I talked to a number of different people. Great. Hopefully you didn't violate the protective order when you did that. And I think at the end of the day, after looking hard at Virginia Code Section 19.2-266, I think our position ultimately is that we think that it would not be permitted under the statute. And the reasons for that, Your Honor, are 2 specific spots in the statute. Section 19.2266 sub 2, which explicitly prohibits electronic media and still photography covering a public judicial proceedings in, quote, divorce proceedings, end quote. The court, Ms. Bredehoff, I understand, but this is a defamation case, so that doesn't pertain. Stop trying to make fetch happen, Elaine. Stop trying to make fetch happen. Not gonna happen. Thank you for appreciating my pun, y'all. I see it in the chat. Sometimes we intend them. Sometimes shit just happens. Should we just go fully pink while we're talking about Elaine? Should we just? I think we should. Yep. We just kind of need to be in the pink room. All right. Let's see. It's not Pepto-y pink enough. We'll have to see if I can make it Pepto-y pink more. But this is a defamation case, so that doesn't pertain. It's not relevant, Elaine. Ms. Bredehoff, well, I understand, but please just hear me out. Because there's a indiscernible on this one, and I really did give it some thought. I'm trying, Your Honor. I'm trying. I'm really trying to make this statute work for me because I really don't want cameras in the courtroom because I know the way that's going to go. Please. I'm trying. And the court lets her go. Okay. Ms. Bredehoff says, and quote, and here it is, this is what was quoted in the motion, proceedings concerning sexual offenses, end of quote. And then Virginia Code Section 19.2-2663 prohibits coverage of witnesses, including victims and families of victims of sexual offenses. Ben Chu should have been jumping up and down right here. Now, the concept behind these, Your Honor, and that's why I brought in domestic proceedings, the divorce proceedings, the concept here is to respect, from the legislature, is to respect the privacy of the inner workings of a marriage, as well as to protect the privacy and the dignity of victims and families of victims. Amber Heard has alleged that Amber Heard has alleged that Mr. Depp has SA'd her on several occasions before and during her marriage with Mr. Depp. This is all quoted up above, which is why I'm going to just skirt through it really a little bit more quickly. There will be testimony on this, not only from Ms. Heard, but from other witnesses weighing in on different things, including medical and mental health professionals. We didn't get a ton of other testimony about those allegations. There also is a sequence here for where the essays were, Your Honor. There's a sequence of other events in telling the chronological story of these things. Ms. Heard obtained a DV restraining order against Mr. Depp in May 2016, which remained in place until they had a settlement on their divorce, which was just months later. Since Ms. Heard is a victim of SA and yeah, her testimony as a victim would be excluded under the statute. Now, presumably, if you technically read the statute as well, Mr. Depp, who was married to Ms. Heard, would be a family member, as would Ms. Heard's sister and Mr. Depp's sisters. So their testimony would be excluded from coverage under the statute. That's not what the statute is full for. Now, Mr. Depp's complaint alleges defamation on the basis that Ms. Heard alleged that she was the victim of domestic violence and sexual violence, the headline, which he has contended is referring to Mr. Depp. One of Ms. Heard's defenses is that's true. That's true. True. Oh my God, this mic tonight. You guys, I'm sorry. It's so frustrating. I really do think it is a software, not a hardware issue. Apologies. Let's see. Now, Mr. Depp's complaint alleges defamation. We got to that. Ms. Heard's counterclaim, Your Honor, includes defamatory statements made by Mr. Depp's counsel, Waldman, which he has admitted saying that Ms. Heard used, quote, fake sexual violence allegations, end quote, and created a, quote, abuse hoax. And the jury found that that was, in fact, not defamatory. One of Mr. Depp's defenses is that this is true. This case really is a case that concerns defamation. But that's not what Elaine says. This case really is a case that concerns domestic abuse and violence in the context of Mr. Depp and Heard's relationship, which I believe the legislature in this statute clearly intended not to include. Now, there are rare instances of cameras and photography in the courtroom in Fairfax, Your Honor, and I spent a good deal of time trying to that would happen. We trust the court, and we certainly trust the court security. We don't trust Ms. Heard. Page 16, this jumped. So page 9, it jumped to page 16. So Elaine keeps talking, and then this jumps to page 16. This must be Ben Chu talking. This must be the end of what Ben Chu's arguing. We trust the court, and we certainly trust the court security. We don't trust Ms. Heard. This court, Ms. Bredehoft, anything further? Your Honor, I take it there must be press in the courtroom for Mr. Chu to have gone on in such a manner. And we can certainly address that. We don't have a problem with transparency, Your Honor. We know the press is still going to be covering this. And you know, we have already won once in the UK. They relied on that so much, it blinded them. Blinded. So let's see. We know the press is still going to be covering this, and you know we have already won once in the UK, and they found 12 acts of domestic violence as well as sexual violence against Ms. Heard. And we certainly, welcome the opportunity for a fair trial. That's not the point, and he didn't address the points from the statute, Your Honor, and that's the concern here, is there's going to be testimony of assault, and it's going to be interwoven with the testimony of beatings. There's going to be a tremendous amount of evidence, Your Honor, a mountain, in fact. That's not what it says here. I'm just interjecting. There's going to be photographs. There's going to be videos. There's going to be audio. There's going to be text message. There's going to be emails. We welcome the opportunity to try this case, but that's not the point. Putting Amber Heard, who is a victim of SV, on camera to discuss those instances along with the beatings is not what the legislature intended, and that's why they prohibited it. The court, all right, thank you, ma'am. I understand you're reading, Ms. Bredehoft, the statute. I do not read it that way. This statute is works for criminal cases, and is mostly used in criminal cases. In fact, not many. I don't know if Virginia has ever had a request in a civil case to have cameras involved. Most of the requests come from criminal cases. That's probably fair, because most of the cases that we see are criminal. And that's where a lot of the public interest generally lies. Most people are like, we don't care if you defamed you, and we don't care if this company gets that money. Most of the time, people just aren't that interested. This is different. Most of those requests come from criminal cases, and obviously, victims of sexual offenses would pertain to criminal matters. Correct. Police informants, undercover agents, this is all in the criminal context, not in civil cases. So when you just look at civil cases, it's up to the court's discretion, and I advise the parties of the possibility of having press, having it videoed, and I don't see any good cause not to do it, especially with the many requests that I've received. I guess there's also, and I don't know, there's some documentary that both parties are involved with, and that I guess both of you already know about. I have gotten a request from that person who wants to have cameras in the courtroom. I've also gotten requests from ABC News, requests from BBC, and others who want to live tweet in the courtroom. I think the cameras were way better than live tweeting. The concern I have also is I have to balance this with the safety of the courtroom, with the safety of the courthouse, and the ability for people to have access to this case and other raised other than just coming to the court. Oh, in other ways, I think she probably said. That's my guess. Other than just coming to the courthouse, it might be a safer place for us here in the courthouse as well. Yeah, if you have thousands of people trying to get into this courtroom with like 100 spots, Cinnamon reads there is a documentary. I think there are multiple, but there is one that the attorneys for Depp, I believe, are involved in. There was video after the verdict on social of Depp's attorneys going into the hotel, and they were being followed by a camera crew. Let's see. The concern I have also is I have to balance this with safety. And I think it's true. I think if they had kept cameras out, there would have been a lot more people sleeping on the pavement. It would have not just have been Rob, who I see in the chat. Hello, Rob, and Runkle and others. There would have been a lot of people trying to get into that courtroom, and press would have been trying to squeeze out the public. And if press is trying to squeeze out the public, it's a problem. You only really had, from traditional legacy media, Chanley Painter in there every day because everyone else just relied on the cameras, which allowed the public to actually be in court because the press wasn't trying to take up all of the space to report this. They could just rely on the cameras, which is exactly what I did. So based on that, let's see. So based on that, I am going to allow a pool camera. I wanted to make that decision now because I'm going to have restrictions. Obviously, there's going to be quite a few restrictions. And if both of you, if you want to file what restrictions you would recommend, I can get that within the next 2 weeks. I'd appreciate it. Obviously, it would be restricted to probably one pool camera is all we're looking at, and we'll have to figure it out. And they could have ties into that camera, all the other media. I do have to, as per the code, I do have to get the Virginia Association of Broadcasters and the Virginia Press Association involved as well, so they can designate the one person to represent the media. And I can start getting the court clerks involved so we can get that set up as well. And we'll have it in place and actually test out probably during our 3 days at the end of March, just to make sure I'm satisfied. If I'm not satisfied with it and I don't think that the restrictions can be taken care of, then we won't have it. But it's going to be a very tight leash. I can promise you, Miss Bredehoft, it will be a tight leash, as you know how I run my courtroom. So it will be a very tight leash, and we'll make sure that we have all the parameters in place prior to the trial starting. All right, Mr. Chu. Mr. Chu, Your Honor, very briefly. And this matter will be coming before the court next Friday, but while we're here, the court, okay. Just if you could give me 60 seconds. The court, sure. For some guidance, Your Honor will recall her order granting Mr. Depp's motion to compel the original devices to the extent that it relates to the photographs. And Your Honor also appointed Craig Young of Cuddick Rock to be the special conciliator, as Your Honor will recall, pursuant to, damn it cuts off. But this is going to go into the original devices. They were still fighting it in February before they brought a motion to compel because it was granted in November. That's over the metadata. Ah! Exhibit D. Courthouse News Service article. And that's it. So I'm going to get to some questions because, I was going to go to Andrea Burkhart's. The other things I wanted to cover tonight, we are just not going to be able to get to. I will go over on Tuesday. Why did it cut off? Because it wasn't an exhibit to this motion. That's why. So because it wasn't an exhibit to that motion, the rest of it wasn't needed. So they didn't put it in there. Why are their pages missing? Because they only put in the pages related to this particular motion when the motion was made. Boo. Let's see. I wanted to get to the stuff regarding the argument over the independent medical examinations of Amber Heard regarding mental health status and from Johnny Depp. So we'll just get those on Tuesday. Again, we've linked to Andrea Burkhart's stuff here, and we will, you guys can go read those, but I will go over those on Tuesday. I'm going to go through some of her highlights on Twitter because I wanted to see what they were. I'm going to be screenshotting Elaine your mic after this. That's my highlight for today. Let's see what Andrea's highlights were. For my last bit of Friday fun, enjoy some examples of Ben Chu calling Elaine out only the way he can. Oh, this is my nightmare. That was a good one too. Seeing multiple Miss Bredahoffs instead of one. Just kidding, Elaine. Let's see. This is not... I've done this badly. Mr. Chu, now you're just being nasty. And if you continue, Miss Bredahoff, I'm not being nasty. You're intentionally trying to drag this out so I don't get to ask the questions, and you know it. Mr. Chu, you're projecting your value or lack thereof onto me. What the fuck? We have to get to that. When did that happen? Oh, Tuesday. Tuesday. Now you're just being nasty. I'm not being nasty. I want to get to that. Dear Elaine, the suggestion that I or anyone on Mr. Depp's team would not take the health and safety of the litigants seriously is false and insulting. It is of a piece when you falsely accuse one of my colleagues of misrepresentation concerning document production, which turned out to be your own mistake, for which you never apologized, and when you falsely accuse another of sexism, for which the conciliator reprimanded you, and for which you never apologized. When you took over as Miss Heard's third lead counsel in this case, I received calls from a respected Fairfax practitioner warning of this type of behavior, but I am appalled nevertheless. We will not be bullied, and I am confident the court will again recognize your accusations for what they are. Boom roasted. For those of you saying third lead counsel, you got to go watch this week's podcast because we talked about it. All right, let's see what Andrea Burkhart's other highlights were. This tweet says, thanks for confirming it, Elaine. As Miss Heard's brief stint working at a strip club just after moving to LA to start her acting career also has nothing to do with her relationship with Mr. Depp years later or whether he abused her. I think that's fair. Like, we don't shame people for the work they do. I think it's a fair argument and it didn't come in. Though Amber Heard has denied it, which goes to her veracity, which is a problem. We don't shame people for the work that they do ever. But if you lie about it, then it's relevant to your veracity. All right, what else? All right, those are the big ones from Andrea Burkhart. I will be very interested in what else we find. So, can you watch the interview with Depp's attorneys on CBS this morning? Not today, but I will. I just have not had time. So I told you guys what I'm interested in going over next. We will be going through more of these on Tuesday. I will probably do an entire podcast episode with probably a highlights of the legal stuff that we gained from this, and then highlights of the legal insight, and then like favorite moments, like spice and sass and stuff like that. So the tea and the legal tea. I think that's what we'll do when we get to them. I'm going to get to questions. You have questions. I have questions. We have questions. There's almost 30,000 of you here. So we're going to talk for a minute. We're almost 3 hours in. So I'm going to have to go. Let me make sure I have to make sure my phone's not on Do Not Disturb because I need to know when to pick my kiddo up. He is going to call me when they are on the bus. So that. All right. Mom things. Mom things. Let's get to questions. Did I swoop? I don't remember. I have questions. You have questions. We have questions. How do I watch a podcast? Morgan Davis. Great question. If you want to watch the video episode of the podcast, they are over on my YouTube channel at the Emily D. Baker. We are desperately trying to get to 666,000 subscribers because I will be entertained. I mean, Mr. Beast just got to like 100 million. I feel like we can get to 666,000. Let me actually look and see how close we are to that so I can let you guys know. There's almost 30,000 of you here. We can probably make that happen. I mean, y'all, law nerds got, things trending #1 on Twitter to the point where Twitter actually had to put an explanation on it. It's just great. You guys do the most and you're fantastic. So let me take a look at where we're at with that. But you can watch the podcast on my YouTube channel, or you can just go to your favorite podcasting app. How close are we to 666? Not. Not close. Not close. We can get this. We can get this rolling, y'all. That's not what I was trying to do. I don't know what that was. Let's try this share screen again because I moved my settings around. WAP. This is a WAP moment. Why won't it let me share my screen? Huh. That's odd. It will not. The last time it was glitching, it just yeeted me from the entire stream. Something is lagging and not lagging nicely. All right, let's try this one more time. There we go. I was trying to show you. There we go. Y'all can watch. We just got here. Sorry about the, and the mic's crackling. The tech tonight is just like, fuck you. We're so close, technology. Stop getting angry at us. So if you go subscribe, you'll get to watch the numbers roll. So anyway, how do you watch the podcast? On my YouTube channel, you can find the podcast episodes. They're under my video uploads, and they normally say episode whatever. They almost always say the Emily Show or TES, but you can also listen on your favorite podcasting app, but only listen. Those aren't video there. So we're manifesting 666. We are. This is the problem. We're getting too close to 666, and the tech demons are like, haha, you think it'll be funny? Fuck you. The tech has released the Krakens, but I think it's a software issue, not a hardware issue. My mic is great. The mic wires are great. This is Todd. This is a huge takeaway. This is a huge takeaway. Chu had been warned about Elaine. Like, her reputation literally preceded her, and we are appalled nevertheless. Yeah. Question, is it normal for a defendant to get up and leave the courtroom during a civil case? No. Alex Jones keeps leaving during his trial. I have not been following the Alex Jones trial much. I did see an article that his attorney had been reprimanded, for sure. You guys are asking, what is WAP? The chat will also inform you, but we use WAP here to mean we are professionals because I fuck shit up in a way that I just need to joke that we are professionals. And we've said we are professionals here for so long. And then one night during the chat, we just shortened it. We were having a conversation about it, and the chat is wise. And most things that happen on this channel happen in community with the chat. So whenever you hear me say we decided, it's me and y'all in the chat, because we do this together. That's why I like streaming so much. We do this together. And we decided that WAP was we are professional. I was today years old when I learned WAP doesn't stand for working ass professional. Oh, Lynn, it sure does not, because it comes from Cardi B. And it definitely means wet ass kitty. So, but not the K version of kitty. Emily, you work so hard here. Love your channel, fan from the UK. Thank you, Panda. I appreciate that. We do what we do. I love it. It is hard work. It's great work. Love it, love it, love it. Question, I ADD'd into 2 dots tonight, so maybe I missed it, but how in the world were they allowed not to produce the metadata on devices? We haven't gotten there yet. I don't know. Y'all are doing all the things. Thank you. We haven't gotten to the metadata yet, so I don't know. I want to know. Did the UK verdict actually find Johnny Depp guilty of DVSA, or that the Sun had reasonable cause to believe that what they were publishing was true? Because that's a pretty big difference. Blasphemous cow. Crow. That says crow. Oh, even in the picture. Apologies. I was thinking UK, and so I was thinking cow in a different way. Brain. It is a big difference. I went through the ruling from the UK court here, and I went through the ruling from the UK court here, and I went through the my breakdown of it after this trial. But yes, they determined that it was likely enough that those incidents were substantially true for the UK Sun to rely on. So Elaine's characterizing it the way she does. Scotty Too Hottie said Amber didn't mind publicly accusing of him, so why the secrecy now? When we're talking about these protective orders, it was Ben Chu and Johnny Depp's team trying to stop her from publicly. Oh, I see what you're saying. You're saying, why do we need it behind the camera when she's been fine to say it? I don't know how much she said it before this trial because I didn't pay too much attention to what she was doing in the media. I think we've seen a lot of it afterwards. So I don't know. But I hope she took time, $5 million worth. Harmless RN. I mean, that's what the insurance company found. Ben did not choose Elaine. No, he did not. No, he did not. Jay Chang said, Emily, new subscriber here. I found you through this exact trial. And while I'm not a lawyer, I'm learning a lot through watching this cover. Thank you. Handmaid Darcy, literally goals, retired audiobook producer, static is always hardware, just often a slightly loose mic cable or poor insulation. We have been having, and other streamers have been having it on StreamYard. It does not happen in my other audio programs. That's why I think it is software, but they are not loose cables. I check them before the show, but I might just change out this cable again, to do it, because it doesn't happen in my other recording programs. But Your Honor, what if anything? What if anything can I do to stop you from putting this on camera? Wish there are times we could mute Elaine and welcome Wood Daddy Stack. It was a stack of defamation today. I was today years old when thank you for that. Sorry, semi-replay crew. Regarding suspension bond, can the judge's ruling override the code? I don't think the judge's ruling says they have to post it. I think the judge's ruling said if it's posted, this is what it will cost. We support all working women and kitties. Yes, we do. All. Rob says he has Elaine flavored tea. Ew. Is it Pepto-Bismol flavored? Because if you add Elaine flavored tea, it would be Pepto-Bismol flavored. Can't follow you or subscribe anywhere else. You're my favorite law nerd. Can't follow you or subscribe anywhere else. You're my favorite law nerd. Well, thank you, Cammie. I'm glad you're here. Question. So do these unsealed documents contain all the sidebar combos in their entirety? No. Or just some of the bits and pieces of the sidebar discussions? Yes, John. Just some of the bits and pieces. Would one need to purchase the transcript separately from the unsealed docs? I don't know if you purchase the documents separate from the unsealed documents, separate from the newly unsealed documents, if you would get all the sidebars. These are coming in for relation to this ruling. I'm waiting to see what we get in the appellate briefs because I'm curious. I wave at you every time you say okie dokie. Well, okie dokie, okie dokie. The dude abides. Mia, the dude does abide. But the dude's not going to abide Elaine fuckery. Tell you what. So you were right. Even on Zoom, Elaine still cannot find her mic. Correct. She gives vibes. Panda, I will have to catch up tomorrow. It's so late here. Thanks. You're welcome. Yes, say the words. Thank you for saying the words. Words matter. We've got you, Emily. Words, Kristen, words do matter. And I'm always torn about self-censorship when I'm trying to play nice with the YouTube gods that be, and also trying to talk about real issues in a non-sensational way. CG is asking, can slow mode be any longer? It cannot. We have maxed out slow mode. Donating to support the realness. Your candor is appreciated. Ambiguous amphibian. That is what I am here for. Candor is a candor. I talked about it earlier today on, I think, Instagram. I'm an Enneagram 1. Candor matters to me. When we look at Divergent, well, No, I probably would have been Divergent. Us neurodivergents are like, where do you fit? Well, kind of candor, kind of, kind of dauntless. But I don't like to run. But would I still make it? Maybe. I do like to punch things. Where's the salty watermelon bourbon, friend? John O'Rourke. I have to go pick up my kid later, so it's not here tonight. Just water and tea this evening. But there was a night for tea. Jeanette, love from AK. We binged. We did bing. Thank you for continuing to cover these documents. You're welcome, Crystal. Though we'd all like to move on, we definitely can't. Merch request, t-shirt front. I stand with Juror 15, back, Law Nerds Unite. We'll see. Do I have this correct? Amber's insurance company Amber's insurance company hired Elaine and company. I have questions. No. Amber hired Elaine and company and they paid them. So that's the phrase we need. Elaine simply was not acting in good faith at any time in the process. Seems that we gave her the benefit of the doubt and that was not earned or deserved. That this is how she operates. And when it was getting shut down, she could not find her footing because her fuckery was not winning. It's like a kid who's used to getting their way when they're like, but please. And then they don't get their way and then they lose their mind and don't know what to do next. What's the name of your peanut butter whiskey, please? Kelly asking the real questions. There are a few. The Screwball is quite good. I love the Tennessee Legend peanut butter cup whiskey. It has a chocolate aftertaste. And I also really enjoy the Old Smoky peanut butter whiskey, but it's more of a vanilla aftertaste. So that. Motion to name Thursday's show Thirsty Thursdays Law Nerd Thoughts. We'll see. We'll see. But yeah, it is, the more I think we're going to see from these unsealed motions, I think the more we are going to be horrified about what was going on. Stacks of Tates, Emily, really? Hi, Rob. Equal opportunity. Manscaped can make them pretty. It's fine. Question, do you think the court of popular opinion would have sided with JD if they hadn't been able to see Amber Heard's problematic testimony? No, I don't. I think, like in the Free Britney movement, we saw people calling the Free Britney crew like crazed conspiracy theorists that were like reading too much into Instagram and all of this until Britney testified in court. I mean, we started seeing it over here. God, I feel like my mic's too high. We started seeing it in court in the court filings ahead of Britney's heart-wrenching testimony in court. But I think for the rest of the world, the New York Times, excellent work by Liz Day is one of the things that changed public opinion, but also Britney's heart-wrenching testimony in court. A lot of the public went, oh, fuck. Did she just say she has a forced IUD? Like, what is popping off here? So from the court documents and being able to see more of them through Sam Ingham finally doing something, and then her own testimony, we got a peek into how bad this was, and it changed public opinion. But before that, the media was mostly maligning the Free Britney movement. And the same thing was happening to those that were speaking out about justice for Johnny Depp ahead of this trial. They were maligned in the media, called conspiracy theorists, misogynists, alt-right, like men's rights, all kinds of crazy shit. And a lot of them, I can't say everyone because I've definitely not seen every account or individual that is, pro Johnny Depp, just like I don't know everything that's gone on in the Free Britney movement. But most of what I've engaged with is people saying something is off here. This is fuckery. Look at all this other evidence. I have questions. What the hell? The media is not telling you the truth. And we saw the trial and then we saw the headlines. And guess what? A lot of the media wasn't telling the truth. And so do I trust that media sitting in this trial would have told the truth about it at the end of each day? No, I don't. I think they are filtered so much through their own perception of the world, which is why we each need to see it through our own perception. Because even if they don't mean to have bias play in, their own worldview is tainting the way they talk about this case. And so I don't think the public would have seen the truth. They would have seen it filtered through a lens. And the media, we see the media lashing out at not being able to control the narrative and not being able to control the lens. They can't control the lens. Kristen says, yet everyone keeps watching CNN and other legacy media. No, they don't. Their numbers are down. Very far down. So no, they're struggling, and they are like in their death throes of trying to discredit alternative voices and alternative media. And we see it across platforms. So, Morgan said, we're still being maligned by MSM, but at least we're not seen as a cult anymore by folks outside the MSM, which is fair. But it's a great question and such a good discussion to have, is that when you can't control the narrative, what we're seeing from the media, legacy media, is trying to vilify those they can't control. And that is absolute fuckery. And that's the problem. Trust that people will make good decisions. Some people are going to still make bad decisions. Some people are still going to make wackadoodly decisions. That's what they're going to do. They're going to make bad decisions. You know what? It's their choice to make bad decisions. If they're not hurting anyone else, then it's not going to be that big of a problem. So, a plain reality said MSM hitched their wagons to a false accusations, making horse, and turned out to be a lying abuser. They can't say they were wrong. Then the rest of their waning credibility is gone. They could have said we had reason to believe this. And I honestly think it's fair for the media to say after the UK case, we had enough reason to believe Amber Heard. And after the trial, that changed. Or at least just report it fairly. Just say, we believe this. We saw this in the UK case. This is what the jury ruled. And stop trying to call everyone that doesn't take Amber Heard's side till the end of time names. Calling people names and trying to put them into little boxes and othering them. We're going to other you by calling you a misogynist. We're going to other you by calling you whatever. Stop trying to other voices you don't agree with. Just say, oh, I don't agree with you. And then maybe say, why do you think that? Hey, I don't agree with that. Why do you think that? What do you have to point me to look at? Let's have a conversation. There's no conversation. It's you're this, shut the fuck up and go away. And I'm tired of it. Could you do a stream with Morgan Tremaine? If Morgan Tremaine would have me, we absolutely could. Have I had time to do any collabs lately? No. But I will. Tonight, I don't know what time it's on, but Nightline tonight, I think I'm on Nightline tonight. It's either tonight or tomorrow, but I'm pretty sure it's on tonight. I know they were shuffling some things around because Will Smith made a statement about the Chris Rock stuff, but I should be on Nightline tonight. When it's on the interwebs, I'll share a clip, but on ABC. If you're up late after the stream, please add Paw Nerd merchandise. There's some, Jody. There is some. Motions, Tea Talk Thursdays. We'll see. We'll have to name, it really might just be Coffee and Cursey Words 2 days, but we'll see. How did she make name partner with all of this underhanded shenanigans and horrendous behavior? Well, some lawyers might value this kind of behavior. Sending love to the mods. The mods are the greatest. And they work so hard, especially I keep streaming so long and our streams are so busy. It's been great. Maggie said, continually referencing the UK trial is even misleading as Welsh and English law are different from Scottish and Northern Irish law. Hugs from Scotland. It's fair to be like, it's not the UK, it's England. You guys are so kind to the mods and me. Thank you. Thanks so much for being my main source of logical thinking and facts. I'm so over the MSM and you are my number one. Well, thank you. I try. And at least I try. And I'm never going to shame you for your opinions. You're allowed to have your own opinions. I just ask that people don't be hateful. That's it. My facial expression when I see one size fits all describes MSN coverage. It's very fair. You don't really mean that. It's very fair. Emily, someone earlier had tangerine margaritas. I'm fascinated. Go find out how to make one tomorrow. Sounds delicious. Thank you, mods. You've been fired tonight. Appreciate you. Haven't they been? Stop trying to other voices you don't agree with. Thank you for saying this. As a PhD student in sociology, this is so important to me. Ali Lona, you're welcome. Aren't we all better off when we're curious and ask people why they think what they think? I mean, if someone's screaming at you and in your face, you don't have to have a conversation with them. But if someone's like, oh, I don't agree with that, it's okay to just ask them why. It's also okay to set boundaries and expect people to have a respectful conversation, like an age appropriate one. I was going to say like an adult, but I have very deep conversations with my kid and we don't always agree on stuff. We've lost a bit of respect for one another, and the othering and the divisiveness doesn't help with that, because when you other people, it makes it so much easier to dehumanize them. And when you dehumanize them, it's so much easier to not treat people with respect. Stop othering people. Start talking to them. We will all be better off. And then those in powers will be like, what the fuck? What are they doing? They're all getting along. They can't get along. Yes, we can. Yes, we can. I'm a little behind, but I desperately want to read the sidebars in Elaine's closing. So do I. If there was a transcript to buy. Elaine, you may not have gotten all this harassment if you had let the original lead counsel remain, but you needed your 15 minutes. Jay Thompson, it's a great point. I begin to suspect that Judge Ascarati had cameras in court partly to protect herself. Patrick, it's a very fair point. I think she saw the need for the media circus to protect the courthouse, because the media would start fighting for seats. We see it in the Britney cases. The media takes up more of the courtroom than the public, and the public has a right to the trial, but if the media needs all the seats, it's a problem. Got a name for the Thursday show, Little Friday Fuckery Recap. I like that. The majority of people are not hard left or hard right. They just want to know the facts and be given enough respect and allowed to make their own choices on what to believe or choose. Yeah, Neil, a lot of us are just purple. It's like, it depends. A lot of things depend. And I don't presume to tell people what's best for them. So stop telling me. Mods, law nerds, paw nerds, and of course you, Emily. Thank you, Irish. Hi, love from India. Can there be a lawsuit against NBC for their documentary misrepresenting the facts found on court and misleading the audience? I didn't see anything where I was like, ooh, that's really bad. It's perspectives. I don't agree with all their perspectives, but I don't see anything from their perspectives that would be hugely problematic. So I would have to watch it again through that lens. I'm sure others have watched it more critically than me. So what do your boys do while you live stream? Susie Q, it depends on the night. Sometimes they go climbing, sometimes T's out at an event, and Dr. B and G are probably gaming. It just depends on the night. Sometimes they watch movies. Abby says, how does it not drive you crazy being a lawyer that people act like that? I thought this is what people became an attorney for, was to search for truth. I don't understand it anymore. Well, in an ideal world, being an attorney should be about a search for truth. In civil law, generally, being an attorney is about vigorously and zealously representing your client. And that is the truth. And that is what comes first, which is why civil law was not my favorite. At least as a DA. Like, as a DA, your discovery obligations are so easy. It's like, redact addresses so no one gets hurt and turn everything over. So easy. Redact out addresses so no one gets hurt and turn everything over. Get protective orders when you need them. Enforce them as you can. But everything just turns over. There's not a lot of fighting over discovery. And there shouldn't be. Give it to you. Christine says, yes, I don't fit in any boxes. Yeah. I hate it when people try to fit me in boxes. Unless it's like, oh my God, are you ADHD? Do you totally forget to eat until the end of the day? It's like, oh my God, that little box fits. Emily, as a parent of a trans person, there's something you said that has helped me so much. Don't have to respect the person to be respectful. Mary, and it's hard. And it's hard. And the chat is so good about that too. It's hard, but people need to remember, just because you don't agree or understand or know something doesn't mean you can't be respectful. But if people push a boundary, it's okay to just move away. Because if people aren't respectful to you, it's set a boundary. And Mary, thank you for your kind words. My subscribers loved my Lawnerd box and agreed there should be a Lawnerd subscription box. Oh, Jen, the amount of work. But I will take it under advisement, my friend. Lawnerd, Susan Bauer suggested for Thursday stream, FAQ around and find out. FAQ around and find out might be the name of our new I Have Questions segments. It's time for FAQ around and find out. That might be the name for our new I Have. Chat, what do we think? FAQ around and find out for our question segment. I think that's just a segment every single time. Elaine is married to a partner at the firm. That may explain some of her antics. Yeah, it does. Esley, it does seem like a family-run firm. You guys are like, yes, yes, yes. Okay, chat. I'm going to let you keep answering that. I'm going to try to get to a speed run of, because I'm going to have to go soon. A speed run of, yeah, I'm going to have to go soon. A speed run of super chats, and then I've got to get going. Emily, thank you so much. Thanks for going over these documents. You rock. Thank you. And thanks to everyone who helped with the crowdfund to pay for the docs. It was great. And we will keep going over it. And we will link her website in the description so you all have it. Defense could never decide between Johnny, the washed up has-been drunk versus the powerful Hollywood power player paying for smear campaigns and perjury. Nicole, it's a really, really good point. They tried to have two different Johnnies and they thought that saying that it was the monster would work, and it didn't. Either he's a pathetic addict, and they called him pathetic in a public state PR statement. Either he's a pathetic addict or he is like a Svengali, like manipulating the interwebs. Sanmar, sorry, I can't stop. This is why I pull my hair back 90% of the time. It makes me crazy. Have you seen Black Belt Barrister's analysis of the UK trial and his opinions on how the judge may be incorrect or even biased? Do you think you'd do a study of the UK case itself? I don't know UK law well enough. The breakdowns I've done are about all the breakdowns I'm going to do because it's also very fact heavy and I can't get to all those facts. The judge discounted a lot of information that I don't necessarily agree with. So the Black Belt Barrister is a barrister in the UK and is a much better person than I to break that down. Let's go for this before August 666K subscribe. Thank you, Betty the cow. Let's see. We're moving and grooving, which is good. But I thought all his supporters were bots, unless the robot uprising is starting. They are sentient and JD stands. Well, yes, that's both. It's both. It's both his in-person people and then the bot army online. It's either this or it's that, but it's all. Tom Franco, you're getting real close to 666 subs. Maybe you can do a special reviewing a court case from the show Lucifer. I like the show Lucifer. Or something else thematic, like a case involving the Church of Satan. I'm sure there are some. Question, why in the world would Amber Heard want Elaine as her attorney? Her lack of professionalism alone would scare me away. So this is something about Elaine. I don't know. Like, is she connected to the Illuminati or the Mafia? Jody B., I'm going to try to say this without disparaging anyone's character because that's not what we do here. But there are times when clients will pick people who match energy with them. And if Elaine was like, I will fight for you, and Amber Heard's like, pick up that sword and let's ride out. This might be exactly the kind of case that Amber Heard wanted to play. There's a reason people choose the lawyers they do. When somebody's gone through this many counsel, it leads me to suspect or wonder if the other counsel was like, this is the truth of what's going on here. And the client is like, la, 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 whatever, la, 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 it doesn't matter. Like, and then it's like, I'm just going to get a new lawyer who's going to tell me what I want to hear. I can see that happening in this case. If he doesn't use the compendium in court, the lawyer will use it to learn to sing and dance like a pirate. It's fair. A bit late, new Lawnerd here, but we'll catch up later. Welcome, replay crew friend. Found these SB in real time to see Judge A. Oh, to see Judge A's face would have been great. Imagine having RB's name and also losing this trial. Rottenborn, who seems to be the most competent counsel on this team. Elaine can't find her Mike Bredehoff is savvy enough to be looking at TikTok and Twitter. Color me not at all convinced. Fair. Question, in your opinion, will this affect Elaine's practice? Probably not. She was a top lawyer in Virginia. Do you think this will change? Well, she was a top lawyer in Virginia who Ben Chu was called about and warned about. So some of those accolades, though, are marketing. A lot of them are paid. They come into my inbox constantly. And I'm like, no, I'm not paying for your stupid accolades. I don't want to play this game. I am disengaging from this fucking hamster wheel. Allie said it's 2022. Who in their right mind is still calling people, right? We all have major social anxiety. Anyone young enough to care about this case is too anxious to make actual calls. Allie, it's a very fair point. If you need to call me, text me and let me know. Unless you are literally one of my 3 BFFs, and then we kind of know when we talk. But you have to breach that gap. What's always surprising to me, and I have a few friends who I now know are going to call me on FaceTime when they call me. No pretext, just a FaceTime. And I'm like, we're doing this. Okay. The gift heart. Today is the anniversary of my heart transplant. Because we please send some Lawnard vibes to my unknown donor and their family. The gift heart. Absolutely. What a beautiful super chat. Thank you. And yes, the Lawnards can all send vibes to your unknown donor and to their family for the gift for you that was life-saving. What a beautiful thing. Finally, I catch your live. I'm usually replay crew. This is so exciting. Welcome. My cats keep sticking their buttocks in my face, and I have to keep trying to watch around them while they squirm on my lap. Yes, they want you to pay more attention to them. Mario said, hey, Emily, I know my girlfriend Tatiana is watching. She absolutely loves your casts. Is it possible for you to say hi and maybe congrats on our 2-year anniversary? Mario, Tatiana, Mario would like to wish you a happy 2-year anniversary. I'm sorry it's so late in the stream. He sent this way earlier, and I was busy yelling about Elaine and her fucking mic. So have a great 2-year anniversary. Can Amber Heard financials be checked to see if she was paid by TMZ for a courthouse photo shoot and cabinet video? No, nobody's checking her financials at this point. Amber Heard didn't make appeal bond. What is it? Is it true? I have no idea if she paid her appeal bond. It doesn't seem she has filed a suspension bond. Yet PG&E can file for bankruptcy and keep hiking up consumer costs to pay for 80 plus deaths. They're on the hook for Camp Fire and Sonoma County complex fires. Businesses are a little bit different. Question, will you or anyone else on LawTube cover the Alex Jones defamation lawsuit? I don't know. I've been a little underwater the last week. I don't know if anyone is covering it. AJ Becky, this is such a sweet compliment. Thank you. Thank you for all the compliments, you guys. I see them. Went on a cruise with my sister and found out she's also a law nerd. Hi, Laura. Here's to drinking and knowing things. I drink and I know things. Quotes that get me through. Taking care of my mom who has dementia tonight. This is helping me get through it. Lisa B, what an act of love towards your mom. Thank you. Barb, Emily, just wanted to say thank you. You've inspired me to go back to school. I'm currently studying to take the LSAT. You're not alone here. If you guys have recently taken the bar, go ahead and pop it in the chat so everyone can congratulate you. My work training class for work decided to do Hawaii shirts for Casual Friday. I am now sporting a purple shirt because Leonard, I love it. Bop it. Perfect. Did you see Camille and Associates CBS interview? Not yet. Transcript pages and columns? Yes. Thank you for answering the chat. I'm assuming that's an answer to the chat. Handmaid Darcy, talk about what's legal and what's ethical. I'm reconsidering my view of both Judge A's even-handedness and Elaine's I'm a silly old woman act. I don't know what this was in context to. Otherwise, I would. So far, I haven't seen fuckery from Judge A. Does Amber Heard have a good argument on appeal? CEG, my interview on Daily Pop. We haven't seen her arguments yet. So I'm open to be surprised, but I don't see anything glaring where I'm like, that's the one. Haven't seen it. Thankful Q said abusers use everything. Consider the timing. If they start this rumor, JD looks abusive. If he puts the bond up to stop her from collecting and or tries to collect, I didn't even think of that. Thankful Q. She'll only do what furthers her own agenda. Classic abuse. Well, I didn't even think of that. So maybe it is leaked by them, but there's been nothing I can see that's credible to it. KH, thank you for the super chat. I love this community too. I love you guys. There's no sidebars unless you pay for all the transcripts, which is different from the unsealed docs. Yes. Why is Elaine constantly allowed to say we won in the UK when technically they didn't? Because nobody's fighting with her. Used to seeing you with your hair up. I think you looked just as cute with it down. I'm going with cute. Thank you for all you do. Well, today it was down for TV things. So I left it down. I'm ready to put it back up. I put it back up so I won't mess with it. Way behind, but finally not. Replay crew. Love your content. Keep me sane while looking for a new job. I just got an offer yesterday. Congratulations, Sam. Yay. Leonard Susan Bauer suggested for Thursday streams, FAQ and find out. I think that's going to have to be. And I think the chat agreed that that's going to be it for I Have Questions. Is there nothing like an appeal that Britney can do for the accounting since her lawyer was... That's a separate issue. And I don't think I have time to cover it well tonight. But it's a separate issue about getting into whether there was conservator abuse and fraud. We're not there yet. But I don't think she's completely forestalled. The processes that are going on in court now are not the processes that would need to happen for that, if that makes sense. So with that, Leonard's, it's been 3 hours and 25 minutes. I'm going to have to go get my kiddo from his event. If I did not get to your question or super chat, I am sorry. I try so much. I try to get to everything. I don't always do it. And I appreciate you guys for understanding that. You are always so compassionate and kind. It's been great. I will see you Tuesday. We are going into August on Monday, and we will be Tuesday and Thursday streaming through the rest of 2022. Congratulations to everyone who took the bar. I can't wait to start seeing when your results come in. You guys don't forget to like and subscribe and do the YouTube-y things. We're rolling towards 666. We'll think of something fun to do. We'll find some kind of cursed lawsuit to cover. It'll be great. So thank you. I appreciate you guys. And with that, take care of yourselves, take care of each other, stay dry, especially in all the places that are flooding, and be well. I appreciate you. Thank you for having conversations with me every single week. We're going to just do more Unsealed documents on Tuesday, I think. And next week's podcast is going to be kind of a Britney roundup of how we got here and what comes next. And hopefully I'll be able to answer some of those questions that y'all have, like what comes next? Like, what are these motions about? What's happening? And what is the next steps for her? Because I think we've got some info on that. So with that, I will see you in the next one.
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.